hearings, the fourth day of hearings for the Regulatory Standards Bill. We're kicking off with a relatively familiar face, Mr. Kapa-Kingi. Eru, are you there?
Hi, kia ora. Te konei ahau.
You've got 10 minutes, and we look forward to your presentation. As you might have heard from members, that if you can keep your remarks within that, it gives us a time to have an exchange with you.
Ka pai. Hoi anō, ko hau tēnei wahana i etahi kōrero mo te kaupapa nei mo Toitū te Tiriti. Nā kei roto i te ingoa, te kaupapa, te anga, te aronga o tēnei kaupapa. Ka hore mo te tōwai ngā kōrero a ngā mātanga i roto i ngā rangi, tata nei e rangi, e whāngai ana i etahi anō tirohanga kōrero ki tēnei pire. So I'm here representing Toitū te Tiriti, a movement that's been growing over the last few years, but of course was part of was the platform in promoting Te Hīkoi mō Te Tiriti last year in November, and most recently, and more specific to this bill, we were the primary claimants in the Waitangi Tribunal in the urgent claim, questioning not only the substance of this bill, but also the process surrounding it. And so the submissions that I'm making today are really just hammering again those points. So the first point I want to make in respect of the Regulatory Standards Bill is that centering around the way in which it's been dressed up and the impacts and the effects that has had, particularly for the communities that I come from. So the way in which this bill has been dressed up, to put it frankly, is sneaky, shameful, and ironically undemocratic, according to Western principles of law. And even the use of the word regulation, one of the first things that I remember learning in my first year studying law at Victoria was the difference between what a regulation is and what other parts of law are, such as statutes and common law through cases heard in the courts. And one of the core differences between regulations and law that we learned is really just around the authority. And regulations, we are told, are secondary type laws that are easy to change and aren't backed in the same way as democratically elected officials, in the same way as statutes are. And so that's the first inaccuracy in terms of how this bill is dressed up, and it's extremely misleading and it's extremely concerning that the title suggests that we are dealing with secondary type rules, but actually the substance of the bill affects a lot more than that. And this bill will directly affect existing and proposed statute law. And to mislead the public in that way is opposite to democratic principle of transparency and clarity. And this is a gravely serious concern, not just for tangata whenua, but all peoples who call Aotearoa home, who would hope and wish and vote for people who vote for leadership in Parliament and government, who can at least be honest about their actions and their attempts in lawmaking. But this will also more severely affect tangata whenua and already oppressed communities who, as it stands, struggle to access, let alone participate in lawmaking practices, lawmaking processes, because of inaccessibility to education and also not seeing themselves essentially as part of these processes. Ki tēnei te ringa o Huhana.
Oh, very good. Thank you. Okay, now I've got Huhana Linden here with her hand up.
Oh, awesome. Thank you, Mr. Chair. I was hoping we could get into some dialogue with our submitters. E mihi nui ana ki a koe te tūngane. You've pointed out, the fundamental flaws in the legislation as it's proposed and the way it's been dressed up. The rush process has been something that has come through really strongly, that it's been like creeping through the night over the Christmas period with that first initial consultation with loaded questions. And now we're in a truncated process. Is that good lawmaking in your view?
Definitely not e te tuahine. Anō kia ko ngā ka kia tēnei e ngā tūpuna he waka kōrari. Pēnei me te Trojan horse e meinga nei etahi o ngā ahurea puta I te ao. He mahi huna, he mahi kuhu. Me haka mā ka tika. Tēnei kāwana I nei mahi nanakia. E mahi nei rātou. And I can also speak firsthand to and compare the level of engagement that we were able to garner as a movement of Toitū Te Tiriti in response to the Treaty Principles Bill, and compare that now to the level of engagement we've been able to garner in response to the Regulatory Standards Bill. Now, the Regulatory Standards Bill numbers are still impressive, and the likes of Tania Waikato, Tina Ngata, and many of those who supported us in our Waitangi Tribunal claim as well have contributed to a very impressive number of submissions, but still nowhere near what we were able to garner in terms of the Treaty Principles Bill. And we've experienced as a team actually just how difficult it's been to market and promote opposition to the Regulatory Standards Bill, which essentially and ironically does the same thing as the Treaty Principles Bill. And so that forces us to question, why is that? Well, the timing is obviously one factor that's contributed to the drop in numbers. Our people have been fatigued, are fatigued, and during the summer, the last thing they want to do is engage in another process of writing submissions and informing themselves of what's happening, even though it's very important. But again, going back to that point at the start of these submissions, is the way in which it's clothed, the way in which it's been described, is also a very hard sell. It doesn't. When you hear the word Regulatory Standards Bill, that doesn't set an alarm in the minds of our people in the same way the Treaty Principles Bill did. And it's also this bill, the Regulatory Standards Bill, has not gotten nearly the same amount of exposure in the media as well. So we've been pushing stuff uphill with the Regulatory Standards Bill, but this is all by design, and it's extremely concerning that that's happening. And also in our process in engaging through the Waitangi Tribunal with this bill and criticising the bill through the Waitangi Tribunal, we engaged a number of experts who required a lot of time, constitutional experts, tikanga Maori experts, who required a lot of time to be able to sit down and digest exactly what this bill does. And if they required a lot of time to do that, how do we expect auntie, uncle, mama, papa, our whānau from our communities, Huhana, to be able to truly understand what's going to affect them the most? So I would describe this, the way in which this bill has been conveyed, or even not conveyed, as cowardly and shameful and completely undemocratic.
If I may supplement, Mr. Chair.
Okay, yes.
Thank you. We heard earlier this week in submissions from our multicultural federations, our migrant communities, their concern at the deletion of Te Tiriti o Waitangi. The fact that we are seeing it systemically taking place across legislation, but for this, in regulation, they said and shared that Te Tiriti o Waitangi is a primary relationship that needs to be upheld in things such as regulation. Do you have any feedback on that?
Te Tiriti o Waitangi is the only reason why a regulatory system or legal system could exist in Aotearoa. So it's ironic that the Regulatory Standards Bill is trying to cut down these po. The first po actually being Whakapūmau, our Declaration of Sovereignty in 1835, and then Te Tiriti o Waitangi in 1840, both of which are po that protect the mana of tangata whenua. But these are also two po that act as a waharoa, as a welcoming to those from other parts of the world to be able to make a home here and to be able to thrive here. And so it's not surprising to me that migrant communities are concerned that these po which uphold tikanga, which uphold manaakitanga, and that are home-making documents for all peoples, documents of welcome for all peoples, are concerned that this Regulatory Standards Bill is directly attacking what are effectively safety nets, not just for tangata whenua, in fact, primarily for tangata tiriti, for ngā iwi puta no i te ao, kia tai mai ki konei, kia taunga te noho, ka ora tātou katoa. And that's why we, as a kaupapa of Toitū Te Tiriti, will always stand in our truth that Te Tiriti o Waitangi is not just good for tangata whenua. In fact, it's good for all peoples in Aotearoa.
Oh, very good. Okay, we're at time now. Thank you, Eru, for coming in and for making your submission before the committee and for submitting in writing as well. We appreciate your time and we wish you all the very best for the remainder of the day.
Toitū Te Tiriti.
Kia ora. Okay, that takes us on, Mr. Clark, to the Manukau Urban Māori Authority, which I understand are in Select Committee Room 4.
Yes.
Very good. Good morning.
Morena.
Morena. You've got 10 minutes. As you saw what worked quite well previously, if you can leave us with a little bit of time for Q&A, that's always helpful.
Is there a minute clock here? Is there a timer in the room?
There is not.
I'll try to stick to that. Okay. Tēnā koutou katoa. Ko Tania Rangiheuea tōku ingoa, ko au te kaiwhakahaere matua o Manukau Urban Māori Authority, Tāmaki. He uri ahau no te aroa Ngāti Awa, Ngāti Raukoa me Ngāti Manu. Nō reira tēnā koutou.
Kia ora koutou, Mike Tukaki, Deputy Chief Executive for MUMA.
I'm pleased to be able to come here actually to, although the bill is in our view a travesty, but to represent the opposition of MUMA, Manukau Urban Māori Authority, to the Regulatory Standards Bill in its entirety. According to the, and actually what I'll do is I'll just briefly introduce our submission by talking generally about what we see as being a fundamental flaw of this bill. Then I'll speak about the concentration of power and political bias present in this bill. I'll also discuss the constitutional undermining of Te Tiriti o Waitangi. And I want to speak more specifically on the disproportionate impact that this bill will have on urban Māori and on Māori communities in rural areas. And lastly, I will just mention our concern about the lack of engagement that this bill has had with Māori communities. According to the Ministry of Regulation, the purpose of this bill is to reduce the amount of unnecessary and poor regulation. On the surface, that might sound like a reasonable goal, but what is most telling is not just what is included in the bill, the so-called principle of responsible regulation, but more importantly, what's been deliberately left out. This omission is not an oversight. In our view, it's intentional. The Regulatory Standards Bill is a rebranded version of the discredited Treaty Principles Bill, designed to sidestep public scrutiny while achieving the same end, the marginalisation of Te Tiriti o Waitangi in lawmaking. And at this point, I just want to say that I support the previous speaker when he spoke about the substantive flaws in this bill. Where the treaty principles attempted to redefine Te Tiriti, this bill goes further. It attempts to erase it altogether from the legislative process. Te Tiriti o Waitangi is entirely absent in this bill. There is no reference to the treaty partnership, no recognition of the Crown's obligation to Māori, and no acknowledgement of the extensive body of legislation, regulation, and case law that embeds Te Tiriti into our country's legal and constitutional framework. This bill, in effect, is a travesty and will take our nation backwards. In respect of the concentration of power and political biases, The bill centralises significant power in the hands of the Minister of Regulation. This minister would have the opportunity and the authority to define what counts as, in their view, good law, and future legislation, therefore, would need to be assessed against their interpretation of regulatory principles. If that minister holds publicly stated views that funding targeted to Māori is racist, or that tiriti obligations are divisive, then it's reasonable to conclude that any future legislation seeking to honour te tiriti will be unfairly deemed non-compliant under this bill. That is not good lawmaking. That is an attack on Māori rights masked as regulatory reform. I want to turn to constitutional undermining of te tiriti o Waitangi. There are several clauses in this bill that raise concerns for us. For example, clause 3, 5, 10, 14 and 18. Those clauses weaken the constitutional status of te tiriti in future lawmaking. They marginalise tikanga Māori and Indigenous Māori legal reasoning. And the bill encourages Crown decision-making that bypasses treaty obligations and thereby undermining accountability and relational governance. This bill has an ambition to pursue without any reference to the treaty. As I said before, it's a deliberate omission. And it's a deliberate omission of the foundational place that the treaty has in our constitution. The disproportionate impact that this bill will have on urban and Māori communities is significant. It will be significant, and it will manifest unevenly across Māori communities, thereby deepening the existing disparities for both urban Māori and rural Māori. For example, urban Māori will experience, and they already do experience, significant structural disadvantage in housing, employment, education and health. This bill's rigid regulatory principles undermine, for example, papakainga and communal housing models, which depend on flexible planning and consent processes. The bill will target funding for Māori services providers and undermine that targeted funding. Māori service providers will be cast or defined as being non-neutral under clause 5 of this bill. Māori-led justice, health and education initiatives, often dismissed as non-compliant if they pursue collective well-being over individual logic, individual market logic. This bill prioritises individualism and individual market preferences. The absence of te tiriti from the bill leaves urban Māori efforts vulnerable to being filtered through a monocultural lens that fails to account for, among other things, whakapapa, whānau wellbeing, and other mana enhancing practices.
Tania, just to give you an indication of time, you've just got over 2 minutes.
Thank you. It's hard to know when there's no clock in this room. Rural Māori face unique pressures. For example, the co-governance arrangements for managing taonga and, for example, Waimaori. Those things rely on legislation that's grounded in tikanga and mana and mātauranga Māori. Community resilience initiatives that have been built up and purposely pursued by Māori in rural areas, those will be undermined. And particularly those addressing climate adaptation, climate change and resource equity. Whenua development projects, they will be constrained by property-centric compensation clauses or deemed non-compliant again under clause 5 of this bill. There has been a real lack of Māori engagement. The development of this bill failed to meet the Crown's obligations under the treaty to engage in genuine partnership with tangata whenua. The absence of consultation replaces a colonial pattern of exclusion and reinforces the constitutional fragility introduced by this bill. MUMA, Manukau Urban Māori Authority, urges this Finance Expenditure Committee to recommend the full withdrawal of this bill and to support the development of legislative processes that honour the treaty and Crown Māori partnerships, support plural constitutional traditions, including tikanga, mātauranga Māori, Māori tikanga-based jurisprudence, and finally, enable equity-focused, culturally grounded lawmaking. That is the substantive submission points from the Urban Māori Authority.
Oh, well, thank you very much. For someone who didn't have a timer, it was perfectly timed. We've still got, if anyone's got a short question for a succinct answer, I'll allow that. Otherwise, we'll let you get on with your day.
If I may, Mr. Chair.
Yes.
Just quickly, this bill clearly puts at the centre individual property rights in terms of lawmaking. I would really just like your reflections on how that fits with what's important to the urban marae and in Te Ao Māori generally.
Well, it's particularly relevant and pertinent to urban Māori, rural Māori, because individual property rights don't sit with it. They are contradictory to Kapa-Kingi, multiple owned lands that Māori unfortunately have to work through a way of getting housing solutions, for example.
Okay.
Thank you.
Yep. Thank you, Dr. Webb. Thank you so much for coming in and for appearing before us in the Parliamentary Select Committee room. We appreciate that, and we wish you all the very best for the rest of the day.
Thank you. Kia ora. Kia ora
Thank you so much. Kia ora. I see Dr. Ford is queued up here, Mr. Clark, so we will proceed with Te Akatea Maori Principals and Leaders Incorporated on Zoom. Dr. Ford.
Kia ora koutou. I understand I'm presenting with my colleague this morning, Bruce Jepsen. Has he?
Yeah, has we got any sign of Mr. Jepsen, Mr. Clark?
Yes, he just needs to accept the promotion to be a panelist.
Okay, are you able to send him an instruction?
He's in now.
Okay, Mr. Jepsen, if you can turn your video on and your microphone on if you're presenting now, and we'll start the clock, Dr. Ford.
Camera's not working. Oh my gosh. Oh, can you hear me?
Yes, we can.
Okay, so my camera doesn't appear to be functioning.
Okay, that's all right. That means that we have even deeper concentration because we can just hear you loud and clear.
All right. Oh, that's a shame. Full access. Oh, no. Right.
Okay, we'll start now. Thank you, sir.
Okay, so you can hear me.
Yep, loud and clear.
Kia ora mai tātou. Ko Bruce Jepsen talking more. He uri ahau o Ngāti Tūwhare Toa Rawa Ngāti Raukawa. This submission is presented on behalf of hundreds of Māori educators, including principals, senior leaders and teachers whom I represent in my role as the CEO of Te Akatea Māori Principals and Leaders Incorporated. Te Akatea provides support and advocacy for Māori leaders, teachers, whānau and learners who have to navigate an education system that evidence shows is racist, unjust, inequitable, and frequently unsafe for Māori. Our written submission has been provided and we ask that it be taken as read. We strongly oppose the Regulatory Standards Bill and we reject it in its entirety. As many of our other allied education organisations have presented in their submissions, there are implications for education in Aotearoa if the Regulatory Standards Bill were to progress.
Kia ora koutou, he uri ahau no muri whenua, nai takatoa, ngā te kahu, ngā pui oku iwi, ko Waimanone toku marae ko Therese Ford ahau. I have several roles in Te Akatea Māori Principals and Leaders Incorporated, and I am here today in my capacity as the leader of our research and development team. Our team is responsible for supporting our national exec to gather, analyse, present and respond to evidence with transformative actions that give effect to te tiriti o Waitangi. These actions therefore must be mokopuna driven, culturally revitalising, equity focused and socially just, so that Māori and non-Māori learners can flourish and thrive in Aotearoa as Te Tiriti intended. We have gathered and analysed the perspectives of our members and present our evidence-based synthesis for your consideration.
Today we're going to focus on two key points in our written submission to articulate our organisation's opposition to the Regulatory Standards Bill. The first point is the exclusion of Te Tiriti o Waitangi, and the second point is the insufficient engagement with Māori. On the exclusion of Te Tiriti o Waitangi, it is the position of Te Akatea Incorporated that Te Tiriti is sacred. We recently told a different select committee earlier this year that Te Tiriti o Waitangi was and is an enduring covenant of care and hope between Māori and the Crown. Our members have asked that we strongly reinforce this message to you all, and one of our members specifically expressed the following statement: "It is the duty of educational leaders to prepare young people for a future in which they can thrive and understand the participatory principles that underlie a social democracy such as ours. They also need to understand that Te Tiriti is legal and binding constitutional foundation for our society and our government," unquote. We agree with the sentiments of earlier submitters who have stated that the exclusion of Te Tiriti in this bill is repugnant. Since the establishment of the Waitangi Tribunal 50 years ago, teachers, leaders, they've all worked diligently to include rather than exclude Te Tiriti o Waitangi in policy and also in practice. One of the transformative outcomes of these efforts has been the establishment of Māori medium education that includes full immersion, koanga reo, kura kaupapa Māori, wharikura, wānanga, as well as bilingual education settings such as reo rua and raumaki. The creation of these unique learning environments was necessary because prior to the 1970s, successive governments had excluded and ignored the place of Te Tiriti o Waitangi in education, which meant that our language and our cultural practices were endangered and they were likely to become extinct. The endangerment or extermination of Indigenous languages and culture is at odds with decent humanity and a clear warning that history must not repeat itself.
Our members who work in these Māori medium learning settings where many of our children are achieving significant success are deeply concerned about the exclusion of Te Tiriti in this bill and what it potentially signals. They have told us that they do not want a regulatory standards board that will inevitably be a Pākehā board to have power that supersedes the rights of our Māori people. This is a direct quote from one of our members. Firstly, the bill must uphold Te Tiriti o Waitangi, not just reference it. Kura kaupapa Māori operate under our own Māori philosophy. Any regulation that doesn't understand or respect that is a risk to our identity and our success. Secondly, we are not part of the English medium system. Applying one-size-fits-all regulations based on Western ideas of efficiency or outcomes will never reflect the real value or effectiveness of our kaupapa. That's not equity, that's assimilation. Thirdly, any regulation that impacts us must include Māori-led impact assessments using kaupapa Māori measures. Cultural, spiritual and whānau outcomes must be recognised as valid, not just economic ones, unquote. Additionally, our members who work in many of the nearly 2,500 English medium schools in Aotearoa are also gravely concerned about the exclusion of Te Tiriti o Waitangi in this bill. It is important to point out that 97% of Māori learners learn in English medium settings. In these schools where Te Tiriti partners learn, teach, lead and govern together, the inclusion of Te Tiriti in policy and practice has seen the naturalisation of Māori knowledge, language and culture. Our children, Māori and non-Māori, embrace opportunities to kōrero Māori, sing waiata, perform in kapahaka, take part in pōwhiri and mihi whakatau, visit local marae, maunga and other culturally significant sites, and learn the cultural narratives and traditions of tangata whenua.
Another excellent example how Te Tiriti o Waitangi has become not only included but embedded in English medium education can be seen with our children and our communities when we join together and we sing our national anthem. For over 25 years, schools have been singing the Te Reo version of God Defend New Zealand, which means we now have a generation who have only ever sung the bicultural version of our national song. Furthermore, the implementation of Aotearoa New Zealand History's Te Ui Matua is providing real balance to a curriculum that for far too long rendered Māori people and their culture invisible. That the exclusion of Māori history, including the story of Te Tiriti o Waitangi, meant that generations of New Zealand students learned inaccurate and therefore untrue narratives about who really originally discovered, explored, settled and successfully established themselves on this whenua, on this land. This raises a critical point to exclude Te Tiriti o Waitangi from a bill. A proposed piece of legislation perpetuates the idea that our founding document never existed. This is a lie, and our members vehemently reject the lie that Regulatory Standards Bill represents.
This brings us to our second point, which is insufficient engagement with Māori. Our Māori leaders and teachers have observed in recent decades that as educators have come to better understand Te Tiriti o Waitangi, they have recognised that meaningful engagement with Māori is essential. We have also heard from non-Māori leaders that they greatly value and in some cases depend on the unique knowledge, perspectives and innovative approaches that Māori provide. Māori are overrepresented in the majority of the negative indices of New Zealand society, including education. In fact, according to the Education Review Office, achieving equity and excellence in student outcomes is the major challenge for New Zealand education. However, there is a plethora of evidence that shows that when educators engage and work with Māori leaders and whānau, student outcomes improve. For this reason, school leaders and board members prioritise the time it takes to develop mutually respectful relationships between themselves and Māori, to listen to each other, to work together, to find solutions and generate mutually beneficial outcomes. Our members report that it is not only offensive that the Māori views on this bill have not been sought. This disregard of Māori perspectives suggests that the architects and supporters of this bill are content with the continuation of intergenerational inequity, and they are therefore prepared to facilitate and exacerbate injustice. This is fundamentally inhumane.
We want to conclude by stating that while there is much work to do, we celebrate the progressive act of truth-telling of biculturalism and collectivism that have emerged in education as a direct result of incorporating Te Tiriti o Waitangi into policy and into practice and engaging in meaningful ways with Māori. If a regulatory standards bill that excluded Te Tiriti o Waitangi and disregarded the engagement with Māori progressed, we fear it would hit a precedent and the honourable, ethical and moral policies and practices of educators would be challenged and at worst discontinued. We urge the Select Committee to replicate the honourable, ethical and moral of many leaders and teachers and reject the regulatory standards bill in its entirety. Nō reira, tēnā koutou, tēnā tātou katoa.
Okay, thank you very much, Dr. Ford and Mr. Jepsen. There's no time for questions. You put so much into your presentation that I didn't want to interrupt you. We're well over time, but thank you for your directness and for your articulation, and we wish you all the very best for the rest of the day.
Kia ora.
Hold up.
Thank you. Okay, that leaves us to the Mangere Labour Electorate Committee. Have we got, I understand we've got Harry queued up. Kia ora.
Tēnā koutou katoa.
Oh, very good. You've got 10 minutes. We look forward to it, Harry.
Thank you, Chair. Thank you for the opportunity to present our submission. I'm here on behalf of the Mangere Labour Electorate Committee, proud members of the Labour Party who are domiciled here in Mangere, in what many call as the home of champions. But more importantly, we are people who care about our community and Aotearoa as a whole. I'll take our submission as read, and I think we unequivocally oppose the Regulatory Standards Bill in its entirety. And I think there's just four key areas, there are four grounds in which we oppose this. The first has been laboured by the two presenters before me, the Māori Principals Association, also our colleagues at MUMA, as well as various other Māori academics or the legal fraternity. Essentially, Te Tiriti o Waitangi has been deliberately omitted. This bill makes no reference to Te Tiriti o Waitangi, and it's not an omission that is benign. It constitutes an act of actual constitutional erasure. Te Tiriti guarantees Māori tino rangatiratanga and a relationship, a genuine partnership with the Crown. So any regulatory framework of this scale must begin with a commitment to honour these obligations. And it's not just a extra side that you order at a fast food restaurant. It's not a box that we just tick, but it's essentially the constitutional bedrock of our legal system, and ignoring it undermines the very legitimacy of any regulatory regime here in Aotearoa. I think the bill centres largely on individual property rights and market efficiency, and those are values obviously reflective of libertarian kind of thought, but that often stands in direct conflict with Te Ao Māori views around collective stewardship and intergenerational responsibility. We can't build a just and equitable Aotearoa on a foundation that disregards Te Tiriti and the Crown's enduring obligations to tangata whenua. And like our previous presenters have stated, there was no real meaningful engagement or a considered approach to engage with our Māori community. Look, second is more a point around deregulation. And in particular, deregulation has already cost lives and livelihoods. I think the bill assumes that, reducing regulatory burdens is inherently good, but recent history in Aotearoa tells a very different story, one where the removal of safeguards has caused serious harm. There's an old adage or a saying that goes, before you remove a fence, you must ask why it was put there in the first place. And regulations exist for a reason, often because of past failures, harm, or exploitation. The so-called cutting of red tape led to the leaky homes crisis, which cost the country, I think, an estimate of north of 47 billion, a burden that falls heavily on the current generation of taxpayers and future homeowners as well. If we also look at weak and absent regulation, which also played unfortunate roles in the tragedies of families who lost loved ones in the Pike River mine disaster and collapse of even our finance companies such as South Canterbury Finance and Hanover, events that devastated lives and eroded public trust. Professor Jane Kelsey pointed out in a Te Ao Māori interview that, Māori and Pacific often are disproportionately impacted by these lack of regulation in industries such as construction, forestry, even in aged care as well. I think in closing off that point, we must not confuse regulation with red tape. Regulation is often a necessary protection, a shield for people, not a barrier to profit. So removing these protections increases risks, not freedoms. And probably our penultimate point is basically, obviously this bill undermines transparency and almost insidiously locks an ideology. It claims to promote transparency and sound lawmaking, but if we were to apply it to its current as it currently stands, it fails its own test. I mean, the regulatory impact assessment raised major concerns that by its own ministry and own officials highlighted concerns. The irony around this whole transparency is that, parts of the regulatory impact statement is actually redacted, and consultation documents have been redacted, and so-called principles of good regulation obviously lock in what many have pointed out as libertarian worldviews that will tie the hands of current and future governments. It's not principled lawmaking, it's essentially subliminal ideology lawmaking disguised as reform. Folks, in closing, I think many submitters have pointed out that, look, I think it's clause 17 where it talks about the establishment of a regulatory standards board, an unelected body with sweeping powers. Wouldn't be accountable to voters, yet its opinions can carry significant political influence and weight. So, in practice, essentially gives a de facto, almost a veto of sorts to an ideologically aligned group. And many people have pointed out, obviously this is acting a large number of some of the core tenets and ideologies. But, we also acknowledge that they're part of a coalition, and its coalition partners have stood by and allowed this to this stage. But in closing, there's no obligation for this board to consider Tiriti, equity, or even environmental protections or long-term well-being. It just sets a dangerous precedent, technocratic parallel power structure that undermines democracy. I think whilst this bill is framed in the language of good regulation, it advances a dangerous ideological position. It ignores the hard-earned learned lessons of New Zealand's regulatory failures in the past, deliberately sidelines Te Tiriti o Waitangi, and operates with a glaring hypocrisy regarding transparency, and proposes the creation of an undemocratic body with the power to undermine essential public protections. At its core, the principle prioritizes a narrow libertarian vision fixated on individual property rights and reduced compliance costs at the expense of collective well-being and the state's fundamental duty to protect its people. Whakapūmau.
Okay, thank you, Harry. We've got a time for a question from Dr. Deborah Russell.
Kia ora, Harry. Awesome submission, thank you. Hey, in your written submission, you talk about the diversity in Mangere, but fully aware of, it's an awesome community, but also you've talked about formal equality versus equity. Do you see, that sort of formal equality, does it work well in very diverse communities?
Well, absolutely not. I think we have to distinguish the fundamental difference between equality and equity. Equity is based on fairness. If everybody receives $1 equally, that's totally fine, right? But essentially, equity is, I might not have had $1 to start with, whereas you, doctor, might have had $10, and therefore we give you essentially $11, altogether. But I've just received $1. Essentially, there's actually that fundamental difference between everyone receiving something that's equal and everybody receiving something that is fair. And if it means that we have to allocate resources, support measures to ensure that everybody's propped up to a level playing field, that's equity in practice. And we see this all the time with low socioeconomic communities. The popular discourse is that we give everybody something that's equal, when in reality we need more resources to bring everybody up to a level playing field, and that's equity in essence in practice.
Awesome answer, thank you, Harry.
Okay, anyone else? No, Harry, thank you so much for coming in and joining us, presenting to the committee your submission. All the very best for the rest of the day.
Thank you.
We'll see you again. Thank you. Okay, that leaves us to Mr. Clark. Have we got Simpson Grierson queued up in? Oh, yes, they are sitting upright and ready to go in Select Committee Room 4. So welcome, Simpson Grierson. representatives, we'll ask that you introduce yourselves. You've got 10 minutes. And if you can leave some time for questions and answers, that would be much appreciated. So please proceed.
Thank you. Kia ora koutou morena. My name's Nick Chapman. I'm a partner in our litigation team. I'm joined by Alice Mander, a solicitor, who will be talking about the Regulatory Standards Board, and also by Sarah Gwynn, a senior solicitor, who will be talking about the impact of the bill on secondary legislation and also Te Tiriti. So we are one of New Zealand's largest law firms, and in that role, we are privileged to work with a really wide range of organisations, from large corporates across the public sector, local authorities, all sorts. And they come to us because they have initiatives and projects, or they have their questions about their operations or some type of disruption, and they want to know how the law impacts on that. They want to know what their rights and obligations are. They want to know what approaches that they should take. And that means that we feel that we're well placed to talk about the impact that this bill will have on our legal system and on the people who interact with it, which is everyone. And regardless of who it is who's interacting with the law, whether it is a major bank, whether it's a government department, whether it's an individual, they all benefit from the law being certain, being predictable, being easy to follow, and being safe to rely on. And in our submission, this bill doesn't achieve those outcomes. And so I'm going to talk through briefly 3 quick examples. Alice and Sarah are going to add to that. So the 3 examples I wanted to pick up was the first around the principles. So the principles of things like liberty, personal security, and the like, a number of which are highly subjective, and their interpretation is likely to be very difficult to advise on, difficult for people to know where they stand. And their application is likely to be highly fraught, and where it's highly fraught, you're likely to end up with disputes which are costly and time-consuming. The second example is around the way in which this bill interacts with our existing legal system and the difficulties that poses due to a lack of clarity as to how this piece of the jigsaw is meant to fit, and in particular the risk of the proverbial and ministerially appointed cat amongst the existing lawmaking pigeons which are highly regarded both in New Zealand and internationally, are respected, are known, and are well established, and the impact that will have. And the final point I wanted to make is around this risk of the retrospective impact of the bill, and it is a fundamental constitutional principle that the law should not have retrospective impact, and that people should be able to make decisions on the law as it stands. Now, each of those examples, and the examples which Alice and Sarah are going to talk through as well, they have real-world implications for anybody interacting with the law. So the first is that where there is uncertainty, where there is unpredictability, where the law is difficult to understand and unsafe to rely on, then we can expect that there will be disputes. The parties will bring judicial review proceedings, that there will be commercial disputes between parties, and all of that takes time and effort away from other initiatives which should be taking place. But the second risk is that even for people who aren't involved in disputes, there's this ongoing risk that they will simply stay their hand until that uncertainty resolves, and that investment opportunities and initiatives that otherwise would come to fruition won't. And the bill's intention of trying to make things easier will in fact slow things down. So I'm going to pass over to Alice.
Thank you. So one of our other main concerns with the bill is with the proposal to establish a Regulatory Standards Board. So as you know, under subpart 7, the Regulatory Standards Board will be carrying out inquiries into existing legislation and forthcoming bills and seeing whether they're consistent with the principles of good regulation. And we sort of have 3 main concerns with this. So the first being that the board as proposed will effectively have post-enactment powers to make recommendations that very well may criticise existing regulation. So as foreshadowed, we think that this is likely to create significant uncertainty and confusion for businesses and communities and industries alike as to the future of that regulation and the consequence of those recommendations. We think this is particularly problematic for industries who rely on the certainty of regulatory regimes. Our second concern is that the House of Representatives already has the role of scrutinising bills against constitutional principles as they go through the House. Perhaps more importantly, the House of Representatives has these mechanisms to allow the public to have an oversight or have say in that process, such as the Select Committee process. So we're concerned that the Regulatory Standards Board appears to sort of overstep into that arena without those accountability mechanisms, and will also potentially cast doubt on the House of Representatives' role to enact good law, which will also potentially be seen as a blurring of the separation of powers, which we know to be so fundamental to our Constitution. Finally, and connected to these points, we think that these issues of transparency and the separation of powers blurring are exacerbated by the fact that the board will not be independent from government, but rather accountable to the Minister of the day. So with that, I will pass to Sarah, who will take us through the rest of our submission.
Thanks, Alice. As Nick said, I'm speaking to what's included in the bill and what's excluded in the bill and how those will have lasting and unintended effects on public entities, local authorities and our communities. So first, looking at what's included in the bill, the application of this bill is broad. It applies to all legislation, including secondary legislation, and it applies retrospectively. This includes regulations setting out entitlements for our key constitutional players in fulfilling their roles, such as Governor-General, MPs, judges. It also includes regulations setting standards such as professional standards, environmental standards, food, water standards, and WorkSafe standards. It also includes secondary legislation delegated to government departments because of the need of their expertise in that industry, such as taxation and regulations governing key lifeline utilities. The bill then places obligations on those lawmakers and administrators of secondary legislation to conduct regular reviews of those laws against the standards outlined in the bill. This is going to place a significant burden on those government agencies, public bodies and local authorities. It's also going to divert their resources away from businesses and community. We also note that within that, the complaint mechanism is broad and unclear and it will apply to all legislation and secondary legislation. Under the bill, any member of the public can make a complaint to the board. There's no standard that applies. So it's likely that it will end up being a cheap, easy option compared to other mechanisms that are in place, such as judicial review. It also means that those lawmakers and administrators of law will need to divert their resources to respond to those complaints. So secondly, what's excluded? As you've heard before, having Te Tiriti excluded from the bill will create uncertainty in our legal framework. The principles of Te Tiriti are not included in the principles of responsible regulations in the bill, and there's no reference as to how the bill interacts with the treaty. The example we use in our submission is that public service entities have requirements to support the Crown in its relationship with Maori under Te Tiriti, and it's unclear how those public service entities are expected to balance the obligations in this bill with their obligations to support the Crown, say even when they're conducting the reviews as required. That silence is going to cause significant uncertainty in many areas. It's also likely to raise the risk of judicial review and legal action, leading to greater uncertainty for industries relying on regulatory schemes. So I'll now pass back to Nick.
Well, thank you. We're very happy to take any questions that the committee might have. Before doing so, the final point that we wanted to make is to encourage the committee to be alert to the existing mechanisms that already exist in our system. So whether that is the Legislation Design and Advisory Committee, whether it's the Regulations Review Committee, whether it's Law Commission, there are a whole bunch of examples which already address the types of issues that the bill is intending to remedy.
Okay, thank you very much. We're nearly at time, but we've got a question from Dr. Duncan Webb.
Oh, kia ora, and thank you for that submission. Always good to hear from Simpson Grierson. Look, it's not something you touched on, but it's very legal. In clause 24, we've got a provision that says the Act does not confer a legal right or impose a legal obligation on any person that's enforceable in a court of law. And yet here we have Parliament passing something which is both a law and not a law. I'm just really perplexed as to how this fits you've talked about judicial review, but if you've got any comments on what that means, I'd be really, and how it works, I'd be really appreciative.
I think that's an important question, and I think the confusion which you're referring to, the confusion that we have identified as well, and confusion that the courts will have to battle with, because the courts on the one hand are being told that this law doesn't have any impact, but on the other hand, passing act into law creates rights and obligations, and the courts work on that basis. And so any party which is disadvantaged by the way that this bill operates would seek to take advantage of that principle and will seek to take challenges. And that is a prime example of the uncertainty which would be created if this bill passed into law.
Okay, thank you. We're going to have to leave it at that. Thank you so much for coming in and presenting.
Thank you.
Thank you for your full written submission, and keep in touch with the process. Thank you. Okay, Clerk's office. Have we got Ms. Nathan online?
Yes, we do.
Marewa? Okay.
Kia ora.
Welcome, Morena. Look forward to your presentation. You've got 10 minutes, and if you can leave some time for some interaction at the end, that's always appreciated. Thank you.
Ka pai. Tēnā koutou katoa te committee. My name is Marewa Nathan, and my iwi is Te Rarawa. I take the Y262 Taumata Whakapūmau submission as read and will now add further kōrero. I'm here firstly on behalf of my people of Muri Whenua. I'm here representing Y262 Taumata Whakapūmau, and more specifically Toitū 62, who is a youth group made up of mukapuna of the original 6 claimants, which was initiated by Te Taumata Whakapūmau, who have tasked them to tiaki and uphold the mauri of the Y262 claim. I am a 7th generational weaver that was raised by my grandparents in Ahipara, a small coastal town at the southern end of 90 Mile Beach. They taught me mātauranga Māori, and along with kaumātua spent hours imparting what we call kōrero tukuiho, or te kauwairunga. In English, this translates to the esoteric knowledge that is handed down through generations. Basically, I was a little Māori kid running around the marae, doing all the little jobs, who then sat with kaumātua, learning about whakapapa and what I now know as ancient traditional knowledge. In 2010, alongside Master Weavers of Muri Whenua, we opened Te Whare Whiritoi at Roma Marae, which is a gallery and art space built to honour and perpetuate taonga Māori. I'm here to oppose the bill for 2 reasons. The first, environmental, and how this will hugely impact negatively on our environment, our weaving fibres, and more importantly, on my people. The second reason is to do with massive violations on traditional Māori practices and the hurt it will cause to mātauranga Māori. Muri Whenua is well known within the rāranga community for the abundance and the wide range of weaving fibres, from coastal fibres to our saltwater and freshwater lakes to our bush and up in our swamps. There's no other region across the country that has a variety like we do in the far, far north. She's beautiful up here, e matua. Rāranga is not just artistic. Just like every other Māori practice, it's deeply connected to the natural environment. It's got cultural, spiritual, and environmental or site-specific relationships, which is all knowledge that's passed down orally through generations and generations. An example of the site-specific relationship is between pingao and tuatua. Okay, pingao is a highly prized golden-coloured spinifex that grows on our coastal sand dunes. And tuatua are a popular shellfish that live in beds along the low tide of the beach. Now, whether it's through natural or unnatural erosions, without the pingao growing on the dunes, releasing pollen, the wind can't sweep it down to feed the tuatua who rely on it to kick off their own life cycle. This means that the shellfish beds don't replenish and my people are left without a food source. Okay, a food source that has fed people from across this country for centuries and is now at risk even more with this bill. The regulation of the whenua, water and biodiversity will have a direct impact not only on the health, accessibility and sanctity of these weaving taonga, but more importantly on my people. They'll be hungry as. I recommend that you engage with local iwi, okay? Engage with Toitū 62 to Taumata Whakapūmau, and that all regulations affecting natural resources must be assessed for impact on mātauranga Māori, and this includes weaving materials and all of its practices. My point 2 is that rāranga is not just about physical practices. There's that esoteric knowledge I mentioned that's passed down through generations by tohunga or experts to those that they have specifically chosen. Okay, this is an ancient knowledge that is not available to everyone. This is a deliberate practice or a protocol that keeps mātauranga Māori protected through tikanga, protected through tapu, and protected through whakapapa. I am a product of these teachings, and I've had a privileged upbringing being taught and guided by tohunga, kairaranga, and those who hold esoteric knowledge. And because of this, I've got a huge responsibility to protect this knowledge. With no regard to te tiriti o Waitangi, this bill will violate Māori tikanga and devastate mātauranga Māori by forcing tohunga to share, disclose, or commodify this ancient protected knowledge. I recommend, like the last one, engage with iwi, talk to us, engage with Toitū 62, Taumata Whakapūmau, and that the bill adds protection for sacred, culturally sensitive, and intergenerational systems. The bill needs to recognise that not all knowledge should be shared publicly. In conclusion, rāranga is a living embodiment of kaitiakitanga, whakapapa and wairua. This is the very knowledge that has kept my people alive for centuries, and this is the knowledge that's going to take them into the future. This bill will only reinforce and remind my people of the Crown's failures to protect this taonga. Without engaging local iwi, Toitū 62, Waitu 62 Taumata Whakapūmau, this ancient knowledge, our natural environment, our weaving resources, and more importantly, my people are at high risk of being silenced or regulated out of existence. Hoi nā no, that's all I've got to say today. Thank you for listening. Tēnā koutou, tēnā no tātou katoa.
Oh, kia ora Marewa. Thank you. Any questions, members? Otherwise, we will have to move on. Huhana Linden.
Tēnā koe, Mr. Chair. I'm not sure how to know whether we have time for questions. I'll leave my hand up at the end. Tēnā koe, Marewa. Ngā mihi nui kia koe mō tērā wāhi kōrero e pāna ki tēnei ture. Really interested in unpacking, you know, the Y262 kaupapa is about protection and recognition of that unique mātauranga that we hold, and the denial of the rangatiratanga that our iwi Māori hold on behalf of those taonga here in Aotearoa. From a youth perspective, because we have Toitū 62 here before us, are you worried for the future if a piece of legislation such as the Regulatory Standards Bill is put in place and it fails to recognise the centrality of Te Tiriti o Waitangi in legislation?
Yeah, massively worried. There's been a stackload of work that our people and across the country have done to perpetuate the growth of this taonga, whether it's in the environment or it's the knowledge within the people. This bill is going to take that backwards tenfold by not including local iwi or experts within their process, and this is going to kill that knowledge.
Okay, we'll leave it at that. Thank you, Ms. Nathan. That's very good.
Nā koutou.
Loud and clear. Mr. Clark, have we got Troy Baisden?
Yes, I'm here.
Yes. Oh, good morning. Thank you for your patience. You've got 5 minutes. We look forward to your presentation.
Tēnā koutou katoa. Yes, I'm speaking to you from the U.S. right now. It's not too great in regard, but I'll point out a couple things related to that in a minute. Let me first say that I oppose the bill. I recommend its rejection. I think there was time to consider compromises and progress that could be made towards better regulation in its formation. And that time is now past, as the bill is deeply flawed and divisive. I know that you've seen a lot of testimony across the two committees. I'll just emphasize Sir Geoffrey Palmer noting it as risible and strange as well as divisive, and Jonathan Boston asking why a sensible parliament would ever enact such legislation, as well as testimony that it was devastatingly failing all tests for credibility. Unfortunately, I also couldn't find some other pieces like the PCE's bits, which I think are very important to integrate with my comments today. Let me now step back and note that the key reasons I cite the Parliamentary Commissioner for the Environment's testimony are that there are plenty of existing pieces of machinery and legislation that can be used in the same way that this bill was intended to be used, and are very much more suited to that purpose. My history and qualifications, coming from the US, I've been in New Zealand for about 25 years now. And I did my bachelor's degree at Dartmouth, one of the smaller Ivy Leagues, not on Donald Trump's list of sanctions against the Ivy League universities yet, where one of the first papers that I took before I became a scientist and ended up in New Zealand working on environmental science for that reason was about property rights and environmental policy. And it warned us of this approach to property rights and how difficult it would be to live in our present century if we went down this path. I then went and got a PhD in environmental science and soil science at the University of California and at Berkeley, and have been through 2 Crown Research Institutes and been a professor at a New Zealand university. I'm currently the co-president of the New Zealand Association of Scientists, as well as a practicing environmental scientist. And that informs part of what I want to talk about briefly here, which is, and I think it's important to understand it in the context that much of what we want to consider as property rights derives from the environment. It derives from the sense of owning land and working land. And that same is true for what we might consider to be the economy. And so the 2 major things the bills are about have a major impact on us as a nation that produces productivity and also needs to take account of the issues of the 21st century in dealing with emissions and all sorts of other forms of regulations. Now, my colleagues in the discipline that I'm really part of, which is biogeochemistry, essentially that's the discipline that puts together the bio and the geo and looks at issues that affect the earth and accounting for elements like carbon and nitrogen, has recently put out the 2nd edition of an editorial that I was involved in when I was an editor 10 or so years ago. And it begins by quoting Aldous Huxley in Brave New World. "Great is truth, but still greater from a practical point of view is silence about truth. By simply not mentioning certain subjects, totalitarian propagandists have influenced opinion much more effectively than they could have by the most eloquent denunciations." And from that perspective, I point out my main concern is that the bill is less about, all the concerns are less about what the bill is than what it is not. The bill is missing the key principles of good governance that should be there if we were serious about better regulation and better lawmaking. I will, however, emphasize one aspect about what the bill does before I get on to my main concerns there, which is that by empowering an oddly powerful board and other initiatives with a strange and incomplete set of principles, it appears to run parallel to McCarthyism, Mao's agents of the Cultural Revolution, as well as possibly things as strange as the Spanish Inquisition. And I encourage deep thought about what can be done about that if the bill is to go forward.
Troy, excuse me, I'll just get you to come to your concluding remarks, because I'd like Dr. Russell to ask a question.
Yes, that sounds good. So the key steps that are missing include principles such as distributive justice, public harms, rights of future generations, and stewardship of a healthy and safe environment. But I think that one of the key issues, if we were to make this a better bill, would be making sure that evidence-informed decision-making is part of making better regulation. Clearly, too little regulation is not the problem, and this bill will lead to great uncertainty. It will lead to our essentially everything but the greater productivity that it seeks. And perhaps most importantly, I worry that it creates a path where our farmland and our housing is put on the market as property rights that can be sold to the highest bidder, largely from other nations. Thank you.
Okay.
Hopefully
thank you.
That question.
Yeah, no, thank you, Troy. We're going to go to Dr. Russell.
Troy, thanks for good to see you, and thanks for putting the submission in. In the PCE submission, he recommended that the bill not proceed, but if Parliament was of a mind to proceed, he would at least like to see in Clause 8, which is the one that specifies the rights, the addition of a clause saying nothing in this section confers a right to pollute water or air, to contaminate soil, or destroy significant indigenous biodiversity. Wouldn't the inclusion of a clause like that go some way towards mitigating some of your concerns around the environment?
It certainly does. I think if I had taken up a full 5 minutes talking, probably the most important thing I would have said is that this is really about having principles that are fit for purpose for the 21st century rather than the mid-20th century. And those principles that would allow us to deal with international treaties around climate change, that would allow us to deal with the international expectations of our markets, those are all principles that are now part of good governance in the 21st century that we're expected to perform to. This bill largely removes the opportunity and ability to do those, so all that can be put back would make it a better bill from my perspective.
Great, thank you, Troy.
Thanks, Dr. Russell. Thank you, Troy. Thanks for beaming in from the United States today to join us. Thank you for presenting and for your written submission.
Thank you.
Okay, Mr. Clark. Excuse me. Have we got Corey Hebberd at the Select Committee Room 4?
Yes, we do.
Oh, very good. Welcome, sir. You've got 5 minutes. We look forward to it.
Tēnā koutou ngā mema o te komiti parimata, ko Corey Hebberd tōku ingoa, he uri ahau no Rangiheuea Waido. I'm here today on behalf of Rangiheuea Waido. And in making this submission, I want to acknowledge and mihi to the literally thousands of individuals and collectives who won't be heard today despite having asked. Rangitania's relationship with the Crown began in 1840 when our rangatira Ihaia Kaikoura signed Te Tiriti o Waitangi at Horahora Kākahu in the Port Underwood. That signature, given in good faith, bound our futures together on the understanding that our rights, our authority and our place as tangata whenua would be upheld. This bill breaks that understanding with something quite dangerous: silence. It lays out the rules for how every current and future law in this country will be judged. But Te Tiriti isn't there, not in the principles, not in the purpose, not even as a footnote. Te Tiriti, the founding constitutional document of Aotearoa, has been omitted from a bill that claims to be about legal integrity and responsible governance. That is a deliberate political choice. Remove Te Tiriti from the lawmaking process and you remove Te Tiriti and Maori from the very foundations of this country. Our rights get replaced by what's cheapest, what's fastest, and then get sold to the public as fairness. But fairness without context becomes a weapon. And in this bill, fairness is defined by terms such as efficiency, property rights, and individual liberty. The very same concepts long used to confiscate our land, ignore our tikanga, and silence our voices. Clause 8, the so-called Principles of Responsible Regulation, allows tikanga-based protections like rāhui to be challenged as breaches of liberty. But rāhui should not be seen as restrictions. They are acts of care. They are intergenerational obligations to safeguard our environment and our people. This bill has no place for such ideas. Clause 43 through 45 give ministers broad powers to demand information from statutory bodies, potentially even iwi settlement entities. The Crown is not entitled to reach into our affairs at will. We are not your subsidiaries. We are not your contractors. We are tangata whenua and we are your treaty partner. We're also told not to worry because the bill excludes treaty settlement legislation. But what about the very regulations and instruments that give effect to those treaty settlements? Customary fisheries regulations, aquaculture legislation, resource management law. These can all be reviewed and undermined through the lens of this bill. This bill is very blatantly a backdoor to unravelling decades of treaty settlement redress. Maybe not all at once, but slowly, quietly and legally. All at a time when the Crown is also taking steps to remove our only avenues of challenge, such as through the review of the Waitangi Tribunal. Some have asked what difference would a treaty clause actually make? It would do exactly what this bill claims to value. It would bring clarity, certainty and legitimacy. It would ensure Māori rights are considered from the start, not patched in at the end. It would require lawmakers to ask, how will this law affect iwi? How does this reflect tikanga? And it would stop economic convenience from being used to override constitutional treaty obligations. Without a treaty clause, Māori rights, treaty rights, become the exception and not the standard. And the danger here is intergenerational. This is not about one piece of legislation. This bill creates a new default setting for how all future laws will be made. A setting where Māori concerns are optional, where our worldview is background noise, where our legal standing depends on whether we're efficient enough to be heard. Strip away the technical language, and this bill is simply a political weapon disguised as reform. It tells us Māori rights are negotiable, treaty obligations are optional, and justice may be delivered, but only on the Crown's terms. If this bill had existed in earlier decades, many of the hard-won gains Māori have made may never have arrived nor survived. Dame Whina Cooper's march would have been labelled as inefficient. Whānau Ora may well have failed a short-term, narrow-minded cost-benefit test. Mā Taitai and Taiapuri would have been ruled a risk to liberty. Treaty settlements themselves may have been blocked for being too regulatory. You cannot build a fair and lasting future for Aotearoa by cutting out the very treaty that holds it together. Rangiheuea Waido calls on you, members, to either work with your treaty partners to drastically amend this bill, or to reflect and give effect to Te Tiriti o Waitangi and its principles in full, or to withdraw it. To pass it as it stands would not only be irresponsible, but it would be a breach of trust and a betrayal signed into law in direct contradiction to many of the treaty settlements that have been so passionately and hardly fought and secured. E te tiamana, that concludes my remarks, and I'm happy to take questions if there's time.
Okay, well, thank you so much, Corey, for leaving members with the opportunity for questions. Any questions? Huhana Linden, was your hand up? No. Anyone else?
Just to say thank you for an excellent submission.
Thank you, Dr. Russell. Thanks for coming in, Corey. Thanks for presenting, and all the best.
Thank you.
Okay, we've also got another one in person, or in the committee room. We've got the Legislation Design and Advisory Committee, Mark Steele, Chair. Jonathan Orpin-Dowell, Member. Simon Peart, Member.
Good morning.
Oh, this looks like a formidable front row here. Can we, if you can introduce yourselves, and we look forward to your 10 minutes.
Thank you very much, Chair. I'm Mark Steele. I am the Chair of the Legislation Design and Advisory Committee, and I'm accompanied today by two of the external, that is non-public service members of the LDAC. I have on my right Jonathan Orpin-Dowell, who is barrister, and on my left Simon Peart, who is a partner in Chapman. Thank you for giving us the time to hear us today. We know that you have an extremely busy schedule. As you will see, we will take our submission as read, and we recommend that the bill not proceed in its current form. And our submission sets out the principal reasons for this. We recommend that if the bill is to proceed, that there are three important changes that should be made. The first is that the bill should focus on establishing a framework for regulatory quality without setting out principles. And we already have a legislative framework for doing that in Part 4 of the Legislation Act, which has not yet been passed, brought into force. And of course, Part 4 of the Legislation Act could be used in conjunction with the role of the Regulations Review Committee, expanded or changed in some way. If principles are to be set out in the bill, because of their potential constitutional significance, LDAC is of the view that we need a broad-based, consensus-driven process for agreeing what those principles might be. The Constitutional Advisory Panel, which reported back in 2013, helpfully set out elements of a process that might meet the needs of a discussion about principles of constitutional import. We also recommend that by default, at least, the principles only apply to secondary legislation, to primary legislation, I'm sorry. This is because the bill raises some particularly complex issues in relation to secondary legislation. If we look at what has happened in relation over time to litigation under the New Zealand Bill of Rights Act, we can foresee that the courts may eventually read consistency with the principles in this bill as an implied limitation on delegated lawmaking powers. That would be problematic given that the empowering provisions of primary legislation already contain significant safeguards and requirements in relation to secondary legislation. Clause 25 of the Regulatory Standards Bill attempts to deal with this, but in its currently drafted form, it's unclear whether it would actually preclude the courts from developing jurisprudence in this way. So for all these reasons, we think the bill as currently drafted should not proceed. LDAC supports efforts to improve the quality of legislation and believes that there's a good framework for doing so and building on. This bill, however, needs substantial further work and change to be able to support those objectives. Would my colleagues like to say anything in addition to that?
Okay, we've got plenty of time for dialogue. I'll go to Dr. Duncan Webb.
Oh, kia ora, Mr. Chair, and kia ora to the members of the committee, and thanks for your hard work. I'm going to take the opportunity to ask a slightly complex question, seeing as you are the expert. Part 4 of the Legislation Act. Now, that legislation took a long time to get through the House, a lot of work and consultation. That Part 4 is entirely about legislative quality. If this legislation were to pass, what would be the relationship between the Legislation Act and this Regulatory Standards Bill? Because it seems to be almost duplicative.
The short answer, I think, is that if the Regulatory Standards Bill is passed, at the moment, there wouldn't be any implications for Part 4 of the Legislation Act because Part 4 is not in force. So there wouldn't be any conflict as such. However, your observation is correct. Part 4 does contemplate the kind of development of standards and disclosure requirements which are similar to the issues that are addressed in the Reg Standards Bill.
Yeah, all right. Yeah, I mean, obviously not enforced as yet, but the intention is that it is enforced at some point. The other point, I guess, is this really unusual situation we've got, and I asked an earlier submitter around having a piece of legislation which explicitly says it has no legal force. This is clause 24 of the Regulatory Standards Bill. Now, cabinet minutes might not have legislative force, but it's pretty unusual, I would have thought, for legislation to have, no force of law, not to be enforceable in any way whatsoever. Have you got any observations on that?
It's unusual. It's not unprecedented, of course. There are examples of legislation in relation to matters as diverse as plain English in times gone by, fiscal responsibility, the proposed taxation principles bill last year were all proposed not to have legislative force. So it's not unprecedented, but nevertheless, as you say, once legislation is in place, it will still affect the approach that the courts take.
I mean, the New Zealand, if I can just supplement for that, the New Zealand Bill of Rights Act, doesn't invalidate other legislation, but we've still got now declarations of inconsistency and Baisden damages on the back of it, right? Could you see that kind of thing happening as a consequence of this legislation?
Yeah, perhaps if I can pick up there in response to Dr. Webb's question. Yes, I think we would expect that if the legislation remained on the statute book for an extended period of time, that the courts would look to it as a statement of principles that legislation should adhere to. And if you look at the cases that come out of the courts already, for a long time, the courts will pick up, for example, the legislative guidelines, which LDAC's got a mandate for assisting departments to comply with, on the basis that although they're not legislative, Cabinet signed off on them as the template for what good legislation should look to. And so you see cases where the courts say, well, when there's an interpretive question about what's the scope of this power, we'll read it in a way that we assume it's intended to comply with the legislation guidelines, even though that's only something approved by Cabinet. We would expect, I think, a stronger impetus to do that if Parliament says, well, we say these are the principles. You can then imagine the case.
To put it in kind of layman's terms, you got a set of regulatory standards here that say private property and non-impairment are pretty important interpretive principles. So if you then go to another piece of law that's not entirely clear as to whether you prioritise environmental property, the courts can get nudged in the direction of property. Would that be right?
I think that's certainly an argument you would expect someone to make, and then you can imagine different courts coming to different conclusions about it. And as you say, I think that when the Bill of Rights Act was passed 30 odd years ago, no one would have expected declarations of inconsistency or Baisden damages, but it became part of the constitutional landscape. And we see the development of the law as certainly advocates are going to push it in that direction. And it's very hard once Parliament passes something to know how the courts will ultimately take it, which comes back to Mark's point about why we say it would have quite a significant constitutional significance. And so the need for care, whatever the principles are, if they're going to be adopted, that they're ones that Parliament is comfortable being used in that way. Because I think that's inevitable that people will make those arguments, and on the margins, that probably will succeed over time, and it could build a life of its own, the way that the Bill of Rights jurisprudence developed a lot from 1990.
Good. I probably had my fair share of questions.
Okay. Thank you, Dr. Webb. Any other questions, members? No. Not that I can see. Okay. We will leave you to it. Thank you, Mr. Mark Steele and colleagues from the Legislation Design Advisory Committee. Thank you for coming into Parliament and for your ongoing work. Okay, that takes us to an individual submission by Mr. Thomas Howard. Have we got him, Mr. Clark?
We don't appear to have Thomas yet.
Okay, we're running a little bit early. Brian Dixon?
We don't have Brian either at the moment.
Well, why don't we break? We're due for a 20-minute break. Why don't we break now? And if you can hold Mr. Howard, who'll be will be 10 minutes late, but let's break now till 10:20, and let's turn our cameras and microphones off. Thank you. Okay, members, we'll give it 30 seconds. How are we looking, Mr. Clark?
We have Brian Dixon ready to go.
Brian Dixon ready to go. No sign of Mr. Howard?
No.
Okay, that's good. Have we got a quorum? Yes. Everyone's got their cameras on. Okay. With Mr. Brian Dixon, we can see a beautiful fern there. Thank you for appearing before us this morning. There we go. So you've got 5 minutes. Whereabouts are you coming from today, sir?
Akatea, Dunedin.
Oh, very good. And what are the temperatures
lovely.
like? What are the temperatures like there?
Don't know about the temperatures. They're better than they have been. Double figures
Yeah,
at last.
is that a bit of sun? Is that a bit of sun I can see shining on the wall?
It is, and it'll probably be in my eyes shortly. So we'll see how we go.
Oh, very good. Okay, we look forward to your presentation.
Kia ora. So, Morena, I want to say that I appreciate the work of this committee and the parliamentary staff who've been working under extreme conditions on fast-tracking this bill through its committee stages. I've got genuine sympathy for the members of the coalition considering the bill, because you are faced with an unfair dilemma to accept unchanged a proposal that purports to be about improving lawmaking. The bill proposes law for which there is no necessity nor place in our legislative system, other than that it was part of a deal done in the coalition agreement, and your parties do feel bound by that. However, in my view, you're not bound to support what amounts to a legislative Trojan horse. Your real responsibility is to the New Zealand public and to the partners of a treaty that would establish this nation and its governance, joining the Crown and iwi in a very long-term relationship. It's your duty to not allow shoddy and reckless laws to proceed through Parliament. It seems to me that you have 4 possible ways of dealing with the bill before you. Firstly, you can recommend it proceeds and face the probably severe legal and electoral consequences of that. Second, you can attempt to amend it to a state that's a bit less unacceptable. That means completely replacing the principles and removing entire sections of the bill. Hardly feasible given the complex problems that you're hearing about this week and are in most of those 150,000 submissions you received and in officials' reports. Thirdly, you could suggest the bill be returned to the Ministry for substantial redrafting based on the criticisms and real consultation. Or you can recommend that this bill doesn't proceed, for which you've heard many cogent arguments from experts in constitutional law and environmental, social, economic and cultural perspectives. My recommendation in my submission is that you not support the bill progressing. Given the 3 previous attempts to introduce similar legislation and 3 rejections by parliaments and your own parties, it's astonishing that the current version remains largely unchanged through a process of consultation, despite advice from eminent experts and departmental officials. Usually proposed laws subjected to that amount of scrutiny are amended in an open process that continues at select committee hearings. However, the advocate for this bill has not been open to making such changes, even those that could have helped it progress. The entire history of the bill does not actually inspire confidence in the lawmaking it offers. The relevant clause in the 2023 agreement between National and ACT has been represented as an obligation to pass the bill unamended by critical review. That's ironic when the supposed intent is to produce good laws. The parties actually agreed, and I quote, to improve the quality of regulation and ensure decisions are based on principles of good lawmaking. On that basis, the Regulatory Standards Act must itself reflect the principles of good lawmaking, which it cannot possibly do while ignoring the knowledge, experience, and advice of those who understand what good lawmaking actually looks like. Also, good law isn't achieved if any one political party seeks to impose its own unpopular concepts on the majority of the people of New Zealand. If the bill itself doesn't follow the rules of good lawmaking, there's no obligation on parties to support it, and doing so would be contrary to your coalition agreement to that effect. Those who stand to gain considerable power from this legislation are actually changing the nature of our democracy and the behaviour of our representatives. You will be held responsible for that happening and for gifting unprecedented levels of power to one minister and an unelected, powerful elite with conflicted interests. Again, I acknowledge the burden on you and the coalition parties who have reservations, as you must, given the weight of evidence and public opposition to this. Your only effective response to that must be to prevent the bill from proceeding. The bill is bad law, developed through bad process. Its premises are not consistent with Aotearoa New Zealand's governing principles and understanding of what constitutes good law. You and your colleagues can prevent the passage of this Trojan horse and have every reason and much support to do so. Thank you, ngā mihi.
Oh, thank you very much, Mr. Dixon. Have we got any questions, members? Dr. Deborah Russell.
Thank you. Thank you, Brian, for your submission and for both the written and the spoken submissions. We've had advocates for this bill say that it's comparatively neutral, that it's just good sense and neutral policy. Do you agree with that sort of view?
If that was the case, what's the necessity for it? There are mechanisms that exist already within our structure and governance procedures. If there's a need to look at those and examine those and improve regulation, that's perfectly adequate as systems to do that. And given public consultation overwhelmingly said that it is not neutral, I would say that that really needs to be heard.
Thank you.
Okay. Thank you very much, Mr. Dixon, for giving your submission from Dunedin this morning. We appreciate that and wish you all the very best for a sunny day down south.
Thank you very much.
Thank you. Right. Mr. Clark, have we got Energy Resources Aotearoa in the Select Committee Room 4?
We do not at the moment, Mr. Chair.
Do we have anyone queued up? We've got a couple in person there. Do we have Wellbeing Economy Alliance Aotearoa?
Yes, we've just had Gareth Hughes arrive, so we can bring him in if you'd like.
Yeah, let's bring in Gareth. He can think on his feet, no problem. How are we looking there?
Mr. Chair, I thought we were due for a break.
We had a 20-minute break. We brought it forward because two presenters didn't appear.
Yeah, I know, but
we had it from 10 till
10:20. But the other presenters just may not be aware that we've changed the schedule.
Yeah, I know. And if we have to have a mini break, we will again, because we are running about 10 minutes ahead now.
Yeah, I'm not sure that Gareth is ready yet, so the committee may like to break if it can.
Okay, let's come back in 6 minutes, 10:35. Thank you, members, for your patience.
Kapa.
Slightly annoying being here in the room.
Look, we've got people. We have Marewa Davidson, Cameron Brewer.
Okay, members, we'll give it 30 seconds. Okay, thank you very much. We're back in session for the hearing of evidence on the Regulatory Standards Bill. We've got Energy Resources Aotearoa here in Select Committee Room 4. You've got 10 minutes. We look forward to your presentation.
Excellent. Thank you, Chair. Look, thank you for the opportunity to speak to our submission. My name is John Carnegie. I'm Chief Executive of Energy Resources Aotearoa, and with me is Angela Parker, our Policy Director, Downstream Energy and Climate. First, a little about our organisation. We're New Zealand's peak energy advocacy organisation, representing the entire energy value chain. We exist to enable constructive collaboration across the energy sector through and beyond our journey to a lower emissions economy. Our diverse membership have a common goal of supporting high quality public policy. Energy Resources Aotearoa believes that regulatory quality is a problem that needs to be addressed, and we welcome the bill's focus on improving regulatory quality by consolidating public policy principles and lawmaking processes into a coherent framework. Presenting a bill to the public for consultation, further scrutiny and evaluation by select committee process is a prudent opportunity to ensure it is as robust as possible, so as adequate consultation. We are not persuaded by claims that delivering on the bill's objectives must be overly time-consuming or costly. Framing it this way reflects a limiting view of the public sector's ability to meet higher standards. It also risks lowering ambition at the outset. In terms of relevance to the energy sector, our sector has repeatedly experienced the consequences of poor regulatory processes. Amendments, for example, to the Fuel Industry Act have increased compliance burdens. The 2018 oil and gas exploration ban was imposed without consultation, leading to significant investor uncertainty and flight. Changes to the Crown Minerals Act created confusion and discouraged long-term investment. And decommissioning changes were described by one of New Zealand's eminent jurists as, I quote, retrospective and constitutionally abhorrent. Poor regulation has left New Zealand with a significant energy security shortfall. New Zealanders depend on reliable and affordable energy to keep their houses warm and our manufacturing economy thriving. Poor regulation has led to a widespread demand response from our industrials over the last 2 winters to avoid blackouts. This is not a sustainable or indeed resilient way to operate an energy system. In terms of property rights, respect for property rights must be a core regulatory principle. New Zealand's energy sector is now seen by many as a higher sovereign risk jurisdiction. All investors, but especially new investors, want to know that their investment made today will be kept whole tomorrow should the government change. This is now uncertain, and this uncertainty is corrosive right across the energy sector as policies flip-flop, entrenching a lack of predictability and damaging investor confidence. In the end, consumers lose. When government actions substantially reduce the value of private property, a clear and consistent framework for compensation must be established to determine when regulations exceed what a business can reasonably bear in terms of legitimate expectations and takings. Our energy sector is crying out for stable and efficient regulation, and the bipartisan approach required for this regulation to endure, to be able to plan and deliver secure, affordable and low emissions energy. I can't overstate the importance of this for New Zealand's economic well-being and investor confidence. Without reliable energy supplies, we cannot have a thriving economy. We like the bill's principles. They reflect established, indeed orthodox, public policy principles. Regulation should be proportionate, efficient, technology neutral, and targeted at a clearly defined problem. Traditionally, these are referred to as market failures and are not simply outcomes that public policy makers do not like. Government failure is as genuine a risk as market failure. When policy decisions are driven by short-term politics, self-interest, or unclear problem definition, they can impose long-term costs on the economy. Any regulatory intervention must be justified by evidence and tested for its net public benefit. A poorly designed regulation can result in lower productivity, higher compliance costs, and reduced investment, and New Zealand suffers from all three. In closing, improving regulatory quality is crucial for enhancing economic performance, fostering investment certainty, and promoting public confidence. We believe the Regulatory Standards Bill offers a genuine opportunity to raise the standard of regulation in New Zealand. Every part of the New Zealand system needs to have clearly defined and easy to understand roles and responsibilities. This includes the continued upholding and respect for our holy trinity of the balancing of powers between the legislature, the executive and the judiciary. In turn, we encourage the Select Committee to ensure the final legislation is principled, practical and focused on delivering long-term value for all New Zealanders. Thank you very much.
Thank you. We've got time for a couple of questions. I'm going to go to Dan Bidwar first.
Hey, thank you, Mr. Chair. Thanks. Good to see you, John, and to you and your team for your submission. Thank you. Just reading your submission, you talk about the need for compensation for regulatory undertakings by government, particularly compensation when there is regulatory changes that significantly impact the investor certainty. I'm just wondering if you can expand on that and provide us an example of what you mean by that. It is a bit odd. I don't think I've read a submission today that has mentioned that. So I'm just wondering if you can give a bit of clarity for us because it's, start with that. Thank you.
Yeah, thank you, Dan. Lovely to see you too. I mean, in essence, we're not arguing that taxpayers should bear the commercial risk of investment decisions of private companies. We're arguing for sound public policy analysis and processes rather than the novel analysis and processes the energy sector has been subject to. Now, a clear example, actually, was the introduction of the decommissioning regime under the Crown Minerals Amendment Bill in 2021. This was applied retrospectively to existing permits instead of being limited to new wells or permits. And the effect of that was the rewriting of contractual conditions through legislation, changing the rules long after investment decisions had been made, but disregarded investor expectations, was implemented without transitional provisions, and it reduced the value of existing assets by the force of law. As I mentioned in my speaking notes, we sought the independent legal opinions from, in fact, two of New Zealand's most eminent jurists, Barrister Justin Smith, KC, and Professor of Law Philip Joseph, who respectively compared this to holding a former landowner liable for a nuisance that they had not committed, and, as I said, quote, retrospective and constitutionally abhorrent. I mean, this, in our view, wasn't a misstep or in fact, regulatory collateral. It was a deliberate move designed to weaken the sector, and it did precisely that, and hence the energy crisis we now face. We'd prefer, of course, the possibility of this not happening again and being avoided, and this is why we support the bill. So thank you for your question.
Thanks, thanks, John. Appreciate your time.
Thank you, Dan. We've got 2 minutes and we're going to give it to Dr. Duncan Webb for a
Kia ora, thank you. Look, along the same vein, I'm interested in your submission. You talk about the last government subsidising decarbonisation, and you talk about that in terms of impairment of property. Is it your argument that government should not prefer decarbonisation projects and that it should be entirely neutral, and that if it does subsidise decarbonisation, it should compensate your industry for the impairment of your property rights?
No, look, I think firstly, it's worthwhile going back to principle that the bill is not intended to stop regulation in the net public benefit, but rather improve the quality of policy making. And I think neither should we think about compensation or indeed the practical effect of this bill as a box-ticking exercise. I mean, each case will need to be assessed on its merits. And I guess what we would say is that we'd hope that any future decisions should be guided by the principles of this bill.
Oh, just for clarity, so you agree that in the right circumstances, preferring decarbonisation and de-preferring oil and gas is appropriate government policy?
No, we think that public policy decisions should be robust, should adhere to principles, and should be determined on the basis of the net public benefit of the decision.
All right, so far you've said not very much at all, because I've asked you a really clear question about whether it's appropriate for government to subsidise decarbonisation projects and whether that would amount to injurious affection of oil and gas property rights. And so far you've basically equivocated and said nothing. Is that where you want to leave it?
I mean, where I want to leave it is that these decisions have to be made on a case-by-case basis on their merits.
Okay, let's leave it at that because we're over time now. But thank you to the Energy Resources Aotearoa for coming into Select Committee Room 4 and giving us a fulsome submission. Have we got Gareth Hughes also in the room, Mr. Clark?
Thank you, Chair.
Thank you. Okay, Wellbeing Economy Alliance Aotearoa, Mr. Hughes.
Yeah, kia ora. Thank you, Mr. Chair.
Oh, there you are. Okay, nice to see you. Some of us saw you in the Justice Committee last month when we were discussing 4-year terms. So it's good to, perhaps there's some momentum. Perhaps your comeback's imminent, Gareth. We look forward to your 10 minutes.
I'm very glad to be out of politics and lots of respect for all of you, old friends around the Select Committee table. Can I just say, I enjoyed working with John when he was a lobbyist, when I was in politics for more than a decade as well. And I agree with him. What the country needs to see is high quality regulation and good processes around it. But I absolutely reject his assertion that it's bad regulation that's leading to our energy challenges in Aotearoa at the moment. You know, I believe it's the ridiculous and unique market structure, the fact we partially privatised it, we run it for private profit rather than public good, that's actually the bigger issue than regulation with energy poverty and our unsustainable energy mix. I can take you to waterways in Taranaki where, because of our previous light-handed regulation regime, it was easier to get a consent on a farm to drill a fracking well for hydrocarbons than it was to get a consent for a drinking well on a farm, and point you to the waterway pollution, which is impossible to mediate because of that light-handed regulation regime. So regulation is super important, and it's why it's a privilege to address you today. I should introduce Wellbeing Economy Alliance Aotearoa. We're an independent, non-partisan think and do tank working to redesign our economic system around the well-being of our people and nature. We use an evidence-based approach and think upstream to develop practical long-term solutions for the public good. We're part of a global network, the Wellbeing Economy Alliance. We've got ambassadors such as Kate Rowth from Donut Economics, Tim Jackson, Jason Hickel, many leading new economists who I'm sure you're familiar with. I just want to reiterate the point. As I sort of demonstrated with the Taranaki example, it's a key tool that helps achieve social and environmental outcomes for the public good. Regulation is incredibly important, and that's why we're opposing the Regulatory Standards Bill. This bill is fundamentally flawed, and if it's enacted, it's going to have profound negative implications for our country, the well-being of New Zealanders, and our environment. We note this is the fourth attempt to have this bill go through Parliament. It's been consistently rejected under successive governments over many years. The bill proposes a very narrow set of principles which inappropriately constrain the ability of government to use regulation to the benefit of society, and I believe it's going to privilege the rights of corporations over the collective interests of our environment, and that's exactly the picture we've seen in our electricity markets. We all Aotearoa recognises the compelling evidence that economic activity, a healthy economy and development relies entirely on a healthy and thriving natural environment and society. I know you're hearing 30 hours of submissions. That's a huge job. I wanted to try and maybe bring in a couple of unique perspectives as part of our contribution to your consideration. For us, I think it's important to place this bill in its ideological context, the ideas behind it. And secondly, I think we can look to Wales for a better way of how something similar was enacted and the process behind it that perhaps we could learn from for the future. To begin with, I think it's important to note we endorse many of the points of other submitters, for example, around environmental risk, the role of the treaty. We were heartened by the massive response to the Treaty Principles Bill and how this was rejected by almost every party in Parliament. But I fear this bill is a backdoor attempt to try and do what the Treaty Principles was attempting to do. We note, ironically, that Section 8 of the bill includes a statement that legislation should be expected to produce benefits that exceed the cost of the legislation to the public or persons. We Aotearoa supports this principle. In economics, it's called the principle of Pareto efficiency, but we note in the regulatory impact statement, the cost of this regime could be as high as $24 million a year with no benefits actually quantified or able to be estimated. So actually it rejects the exact logic contained in this bill that the costs are exceeding the benefits. It's no exaggeration to say this bill is important. You can see that in the scale of submissions, more than 150,000. I was one of the submitters over summer making a rare submission to the Ministry of Business, Innovation and Employment. It's pretty unique that you get 23,000 people making submissions over summer to a government department. I was sending mine from a little bit of cell signal I got sailing in the Marlborough Sounds, but we endorsed the wide range of opposition, everyone from legal and constitutional experts, economists through to former ACT MPs. I'd point out this bill is divisive at a time when the Alderman 2025 Trust Barometer found trust in government is dropping, with 58% of New Zealanders believing the government leaders are purposely misleading the public. That's not a direction we want to continue to track down. I want to touch on the context for the bill, how this has come before Parliament and the ideas behind it. And I can't put it much better than the Right Honourable Winston Peters, who said, "For too many New Zealanders have come to view today's capitalism not as their friend, but as their foe. The experiment of unbridled irrational neoliberalism has transformed what was once one of the most egalitarian societies in the world into a case study of acute inequality. The truth is, after 32 years of neoliberal experiment, the character and quality of our country has changed dramatically, and much of it for the worse." Why this legislation is important is because I describe it as source code legislation. I find talking about operating systems like we have in our phones as a good example of how we can consider economic operating systems. You'll all have Google or iOS operating systems on your phone. That allows what apps or programs or functions you can run on your phone and what you can't. Throughout Aotearoa New Zealand's history, we've installed other operating systems, the 1890s, the 1930s, the 1980s was the last time we had a major software operating system upgrade, and this is the context this bill operates in. We're trying to introduce legislation which will affect every other decision that a government will make in future years. It was 41 years ago about this time of year that Roger Douglas brought neoliberalism to New Zealand and installed this radical operating system following the example of Reagan and Thatcher. The idea behind it was that individual focus, a smaller state, privatization, deregulation, less social safety nets would boost economic growth, and that would trickle down. But that hasn't been proved in reality. The idea that wealth would trickle down has not created opportunities for large numbers of people, and it's created environmental damage that's actually limiting the economic and life aspirations of future generations. 40 years on, we're still feeling and dealing with the intergenerational fallout. This should be a concern to members all across the political spectrum, and even former National Party Prime Minister Jim Bolger believes neoliberalism has failed Aotearoa New Zealand. We've seen some of the fastest growth of inequality of the world. The Employment Contracts Act weakened the bargaining power of workers who have missed out on much of the benefits and the fruits of economic and productivity growth. Housing's become more of an investment and less about actually homes for people. And now we've got some of the most unaffordable housing in the world. I could go on and on with examples of how this system has come to lead to a less public good context in New Zealand. That ideas behind the revolution operating system we installed in the early 80s can best be seen in the principles behind this legislation. The intent is to reduce the amount of regulation. The principles to achieve this aren't self-apparent. They don't come from any independent source. They don't have the mandate or the backing of the public. They've come from a right-wing think tank, effectively, and continue to promote the idea that the state should step back, should be as small and minimal as possible, and that corporate rights should trump public good, and maybe some of the benefits will trickle down, or we can use some of the growth to afford to pay to clean up the social and environmental mess. I'm aware that the regulatory takings clause isn't legally binding, but this is going to have a chilling and structural impact on future regulation if this bill passes. Compensation for tobacco control, fishery changes, land use planning, the impact on forestry development or carbon pricing are all at risk if we undertake this approach. I'd like to point out that another one of the principles is that the principle that we should impose a fee for goods or services only if the amount of the fee bears a proper relation to the cost of providing a good or services. If we undertook this approach, this rules out Pigovian taxes, which are taxes on activities that generate negative externalities. It's a widely respected principle in economics and public policy that you can use fees and regulation as an incentive to promote, say, a low-carbon sustainable future for all of New Zealanders. I think the list of principles, again, hasn't come with any sort of public mandate. And in our submission to MB, we pointed out that perhaps this list should have considered other principles, such as protecting the interests of future generations, which I know is also about to be removed from the Public Finance Act, protecting the right to a clean and healthy and sustainable environment, widely accepted principles of distributed justice, such as meeting the needs of all people, the requirement to comply with international law, the precautionary principle, the public harm principle, appropriate consultation requirements. There's a huge list of principles which are absent from this bill. And I want to leave you with a last positive, constructive suggestion. We can look to the example of Wales with their Wellbeing of Future Generations Act 2015 to have an alternate model, how similar source code legislation, an act which then affects the functioning of the public service, all other regulation and government decisions, came about not through this process, which is only in front of you because of a coalition government formation agreement and with the genesis from a right-wing think tank. Instead, in Wales, what they did with their Wellbeing of Future Generations Act 2015 is undertook widespread deep citizen engagement. Their Wales We Want consultation process engaged more than 6,000 citizens. And what happened, rather than the government or a particular political party proposing the 7 goals for the Welsh state, this was developed through that deep consultation, then embedded in legislation. That's now survived more than 10 years. It's survived successive government changes because of that enduring response. We see the widespread opposition to this bill today, but also previous iterations of it. I would wager to say that future governments would be repealing this act if it ever became law. This is why, if we want to encourage high quality regulation, which I believe all citizens and all political parties want to achieve, we need to have genuine public buy-in, understanding what the principles are behind high quality regulation. I would urge the committee to reject this legislation and instead propose, if we do want an improved regulatory regime, let's actually undertake a citizens' assembly, for example, which have been so successful in Porirua and Tamaki Makaurau and other cities and countries around the world. Let's look to other examples like Wales, who devolved the key decision-making function to the citizens rather than this narrow ideological bill that's further entrenching this neoliberal operating system we live in today. Thank you again for the opportunity to submit to the committee, and all the best for your considerations.
You're on mute, Cameron.
Thank you, Gareth. We're over time, but we're ahead of time if you get the drift. So I'm going to give Dr. Russell a quick question on the promise that it's a succinct answer.
Hey, thanks for the excellent submission, Gareth, and both written and spoken. Paragraph 22 of your written submission, you recommend adding a new subclause that legislation should protect Māori in the unqualified exercise of tēnā rangatiratanga over their lands, villages and all their treasures. There's been a lot of commentary around this bill not acknowledging the Treaty of Waitangi. Would your subclause go some way towards fixing that?
Oh, I believe so. Our primary recommendation is to reject this legislation entirely, but if you are able to improve it, that would go a small measure. There was minimal consultation with Maori in the development of this. I think that's a massive oversight. And when you have source code legislation such as this, it's egregious to ignore Te Tiriti o Waitangi.
Kapai, thank you.
Okay, thank you so much. Thanks, Gareth, for joining us this morning. We appreciate you making a submission and appearing before the committee. All the best for the rest of the day.
Mr. Chair.
Yes.
We have the New Zealand College of Public Health Medicine as our next submitter, just ready to go. So we can move to them next if the committee's ready.
Okay. Yep. No, we're ready. So let's do that.
Kia ora koutou.
Kia ora.
Just trying to get my video sorted out here. Ko Anna Stevenson tako ingoa. I'm here today as the President-elect of the New Zealand College of Public Health Medicine, alongside our current President, Professor Sir Colin Tukuitonga. I want to thank you for the opportunity to present today. The College of Public Health Medicine is the professional body that represents the medical specialty of public health medicine in Aotearoa, New Zealand. Public health medicine is the branch of medicine that deals with population health policy and strategy, the promotion of good health, the control and prevention of disease, and the organisation of public services. We'll take our written submission as read. We just want to highlight some of the key points today. Firstly, we want to be clear that we strongly oppose this bill. In particular, we are deeply concerned by, as are a number of your other submitters, by the bill's omission of a principle that reflects Te Tiriti o Waitangi. Te Tiriti o Waitangi is one of our foundational constitutional documents. In his submission to the Waitangi Tribunal's urgent inquiry on the RSB, Professor Andrew Geddes pointed out that understanding Te Tiriti in this way provides a narrative basis for our collective commitment as a society in which various peoples can coexist, tangata whenua and tangata tiriti. It also provides the structure for enacting the kind of changes that are needed to correct the significant health inequities for Maori in our society today. We note that government officials have flagged to you already concerns that by excluding a principle reflecting Te Tiriti, the bill could place at risk existing programs that are designed to improve health and wellbeing outcomes for Maori. In a context that I've already said, huge health inequities exist. The New Zealand College of Public Health Medicine believes that key public health priorities for New Zealand should include fulfilling the purpose of the 2022 Paiora Healthy Futures Act, which includes achieving health equity and a particular focus on the health outcomes for Maori, stabilising climate change and ensuring healthy environments for future generations who will live in this land is critical, and stopping the health harms from commercial determinants of health is another very important priority. To achieve priorities like this, there's a need for a future-focused, long-term governance approach, an anticipatory governance approach, if you like, that centres the health and wellbeing of communities and individuals in all policy making. And as it stands, we believe that this bill will undermine the ability of government to address the public health priorities that I've mentioned. The principles that the bill proposes are centred on individual rights and property rights, and excluded altogether, as you just heard from Gareth, are a wide variety of principles that speak to the wider public good, such as public health, the well-being of future generations, the environment, planetary health, and the rights of Maori. This reflects the bill's focus on the private harm principle and a failure to include a public harm principle. A public harm principle would allow for constraints on individual liberty in order to protect the public interest. Many evidence-based and highly effective public health measures. Sorry, can I just check that you can hear? I see that Colin is struggling to hear.
No, we can hear you loud and clear, Dr. Stevenson.
Okay, sorry, I just see him in the chat saying that he can't hear me. So carrying on, it reflects the bill's focus on the private harm principle. Including a public harm principle would allow for constraints on individual liberty in order to protect the public interest. There are many evidence-based and highly effective public health measures that require restrictions on individual liberties to reduce public harm. And examples include pandemic response measures, regulations to reduce harm from the commercial determinants of health, such as tobacco, alcohol, and ultra-processed food. We, alongside many other presenters this week, are concerned that as a result of this bill, measures designed to protect the health of our population could be deemed inconsistent with the proposed benchmark for the legislation that the bill's principles are intended to establish. It would be deeply disturbing if governments had to pay, quote, fair compensation, unquote, for the loss of profits incurred by commercial entities as a result of any regulatory measures that are designed for the public good. And we believe this could lead to governments deferring such actions, a phenomenon known as regulatory chilling. Earlier this week, you heard from Dr. Boyd Swinburne, who gave a case study of the impact of the tobacco company Philip Morris taking a case against the Australian government, which took over 9 years and $50 million. So we think that this concern about regulatory chilling is not unwarranted. Given our concerns and those of many other eminent experts who you have read their written submissions and heard from them this week, we recommend that the bill should be withdrawn. Should it be progressed, we urge that it be substantively modified to ensure that governments are able to balance a range of rights and interests, including the public good, and to meet obligations to Maori under Te Tiriti or Waitangi and to pursue health equity in this country. Thank you. I'm happy to take any questions. I'm hoping that Colin is able to hear any questions if you have any.
Okay. Thank you, Dr. Stevenson and Sir Colin. We've got questions and we've got time for it. Dr. Russell.
Thank you, Mr. Chair. Dr. Stevenson, I'm looking at paragraph 10 of your written submission, and that one you say that the proposed principle of consulting is being narrowed from those substantially affected to those who are directly and materially affected, and you say it's likely to have adverse implications for Māori. Can you just speak to that a little and draw that point out a little bit more, saying why you think it's going to have adverse implications for Māori?
Well, it's a long and complicated answer.
Okay. Try the short version. Assume some knowledge.
Yeah, I think a lot of this relates to, the long-term impact of colonisation, which has led to the socio-economic differences between, there's a generalisation between Maori as a population and Tangata Tiriti, which means that Maori are often not in the spaces and places that are going to be putting forward proposals that will be affected by this bill. Textbooks, whole university courses around this, but essentially we have a population whose socioeconomic status is generally often much less than Pākehā, and therefore they're not going to be in a position to be compensated or to be part of these processes.
So if I think I'm understanding this right, basically because Māori have, as a generalisation, you say, presumably just fewer assets, fewer resources. They're not, because they start out with less, they're going to be affected less, therefore they're not directly and materially affected by a proposal. Is it?
That's a great way to say it. Thank you.
Great, thank you. Right.
Very good. Any other questions for Dr. Stevenson or Sir Colin? Sir Colin, you wouldn't want to add anything at this point? Because you'd be most welcome to. If you do, we're just going to take you off mute. I know you're operating off an iPhone, which is never easy.
Yes, sorry, I've been having fun and games connecting. Thank you very much, and good morning. Just to back up the point just now on the issue of Māori, I think it's a fundamental problem to omit the Tiriti in the proposed bill if the bill does go ahead. That the treaty, the Tiriti is a founding document of our country, makes us unique as a nation in the global community. To omit the principles and the treaty is a fundamental error.
Okay. Thank you for those comments. Thank you to you both. Thank you, Sir Colin. Thank you, Dr. Stevenson, for that presentation, and we wish you all the very best with your ongoing work.
Thank you very much.
Thank you for appearing before us. Okay, Mr. Clark, does that take us to Michael Baker, Professor Baker?
Yes, that's correct.
Okay, we've got Professor Baker here. He needs no introduction. Public Health Communications Centre. Welcome, Professor Baker.
Well, tēnā koutou katoa. Huge thank you to the Finance and Expenditure Subcommittee for this opportunity to make an oral submission on the Regulatory Standards Bill. This oral submission is on behalf of the directors and senior staff of the Public Health Communications Centre based at the University of Otago in Wellington. I'm the director of the centre, medical practitioner, public health physician, a professor and researcher at the University of Otago. This submission expands on points in our written submission. Just to summarise, we consider the RSB to be bad law that is unnecessary, unworkable and harmful to public health. And consequently, it should be rejected and not proceed beyond the select committee stage. We've got three major objections to this bill. The first is that its broad operation takes Aotearoa, New Zealand, in a direction that is harmful to our health, well-being, equity, environment, and long-term prosperity. Secondly, that it will have a chilling effect on law and regulations designed to protect and promote health and equity. And thirdly, that there are actually far better ways of scrutinising and improving the quality of current and new legislation that are less costly, less clumsy, and less undemocratic than the mechanisms proposed in this bill. So I'll just go through those areas in a little more detail. So in terms of looking at the broad operation of this bill and where it takes New Zealand, the explanatory note in this bill talks about the purpose is to reduce the amount of unnecessary and poor quality regulation. It talks about providing a benchmark for good legislation through a set of principles of responsible regulation. And as previous submitters, such as Professor Jonathan Boston, have pointed out, there's no university agreed benchmark for good legislation in relation to both the substance and the process of this legislation. His submission argues that this is actually an impossible goal. But if we were to imagine for a moment that it might be possible to define a set of such standards that good legislation should meet, it's an interesting question. What standards would most New Zealanders expect to see on that list? They would almost certainly want these standards to broadly reflect the kind of society that most of us aspire to live in. They would no doubt include some of the principles listed in this bill, such as upholding the rule of law, but we'd also expect to see other standards in regulation, such as human health, safety and well-being, fairness and equity, environmental integrity and sustainability, protecting privacy, Maori rights and the principles of Te Tiriti. If this bill is to become law that defines high-quality legislation and stewardship over the regulatory system, then we would all care deeply about how it defines quality. The current bill reminds me in some way of Oscar Wilde's adage, a cynic is a man who knows the price of everything and the value of nothing. And on that basis, this appears to be a very cynical bill. If we were to convene a citizens' assembly of a representative sample of New Zealanders and gave them the task of generating a list of principles that all current and future legislation must meet, what would they come up with? I think their list of standards would look very different to those in this bill. Even better if we weighted this group towards younger people who inherit the consequences of the world that this bill envisages. I think the list would look utterly different from this bill. I'm sure their standards would include a strong focus on creating a more sustainable society and economy and protecting the rights and interests of future generations. And some countries do have legislation around this very goal. So I'm also interested in the shift of power relationships that this bill will enshrine. You've already heard from Health Coalition Aotearoa that about what drives ill health in New Zealand. And then and nearly 1/3 of the overall preventable health loss in New Zealand is caused by unhealthy diets, obesity, tobacco, and alcohol. And these modifiable risk factors are strongly influenced by large global industries that profit from producing and very effectively marketing unhealthy products. And we call this the commercial determinants of health. And we need legislation that shifts the balance of power towards strong controls of these industries. Yet the RSB appears written to help enshrine these power imbalances. The second major point I want to make about this bill is that it will have a chilling effect on public health legislation and regulation. I fully understand that the bill does not confer legal rights that are enforceable in a court of law, as clarified under Section 24. However, it does shift the discourse around current and new legislation and regulation in a highly unbalanced way, as has been described. The principles include provisions that will have a chilling effect on public health law and regulation, as you heard in the last submission. For example, the takings or impairment principle, Section 8, would enable commercial interests to seek public compensation if legislation impairs their intellectual property or reduces their profit. And there are many public health examples where compensation could potentially be claimed, or at least the spectre of compensation would be raised by this legislation. For example, tobacco controls such as denicotization, alcohol restrictions such as sponsorship bans, controls on unhealthy food and drink such as limiting marketing to children, and clean air provisions such as mandating emission reductions. In addition, by enforcing a narrow private harm standard, also in Section 8, and rejecting the public harm principle, the bill would limit the government's ability to act in the public interest, limiting the scope of future public health protections. The third area I think is much more positive, and that is that we already have far better ways of scrutinising and improving the quality of current and new legislation that are less costly, less clumsy, and less undemocratic than is proposed in this bill. And in many ways, the RSB fails in its own implicit standard, which is to clearly define the problem it is intended to fix and demonstrate that there are not simpler, more efficient, and lower cost ways of achieving similar benefits. For example, one area that I'm very familiar with are regulatory impact standards. And this process, of course, is managed by the Ministry of Regulation, which is overseen, of course, by the Minister of Regulation. There's an impressive process for production and quality assurance for these RIS documents, and it's described on the Ministry of Regulation's website. This includes the requirement to show evidence of efficient and effective consultation with stakeholders, key affected parties, and relevant experts. And once completed, the RIS document is submitted to Cabinet along with the Cabinet paper. They're published online, including when the bill is introduced into Parliament. And this process appears to deliver most of the additional scrutiny of legislation and regulation that the RSB is proposing. It also puts the responsibility on the government agency generating the legislation or regulation. And it does, of course, make the RIS available widely to decision makers and ultimately the public. And best of all, it does this by not creating a whole expensive new bureaucratic process as is proposed in the RSB, which would include an unelected regulatory standards board and all of the infrastructure needed to support this process. I know that other presenters, such as Sir Geoffrey Palmer, had described the many parliamentary mechanisms for reviewing legislation, such as the Regulations Review Committee. And Professor Jonathan Boston has talked about how this legislation fails to recognise and address some of the major causes of regulatory failure in Aotearoa, New Zealand. And some of these could be addressed in a far more comprehensive way. For example, supporting our current scrutiny systems in compliance monitoring and improving regulatory stewardship, reviewing and evaluating existing legislation, and building a skilled public service workforce to carry out all of these processes. So in summary, our conclusion is that the bill is harmful to public health, unnecessary and unworkable. And as a doctor with a strong focus on protecting public health from infectious diseases, I can think of a number of metaphors. I note that this bill is now making at least its fourth return to threaten us. It seems time to end this later resurgence and consign it to the same fate as smallpox. Thank you.
Okay, thank you, members. Have we got any questions for Professor Baker? Not that I can see, Professor Baker, a very full and fulsome submission. Thank you for your time. Thank you for beaming in from Otago University this morning.
Thank you.
Thank you. Okay, that takes us to an individual submission. Mr. Clark, have we got Paul McMahon online?
Kia ora.
Kia ora, Paul. Welcome to our hearings. You've got 5 minutes. If you can leave a minute or so for any interaction, that would be useful, but we're in your hands.
Right. Thank you, Mr. Chair. Kia ora koutou, honourable members. Thank you for the opportunity to speak. I wanted to make the case against this bill from a position I believe many of you share: a commitment to democratic sovereignty, responsible stewardship, and practical, effective government. The stated aims of this bill, improving transparency, scrutiny, and accountability, are laudable, but I would urge you to look closely at the architecture of the bill. It does not achieve those aims. In fact, it risks undermining them. At its core, this bill is a Trojan horse. It appears to promote good lawmaking, but in substance, it elevates an extreme and anti-empirical ideology, one that privileges private property rights above all other democratic values. It does so in a way that would constrain future parliaments, inhibit regulatory flexibility, and open the door to costly compensation claims by powerful commercial interests. Let's be clear, this bill doesn't come from the mainstream of New Zealand's legislative development tradition. It comes from ACT's long-standing and extreme libertarian project, first drafted by the Business Roundtable in the early 2000s and rejected multiple times since. It wasn't a Nationals manifesto, it wasn't a New Zealand First manifesto. It got here through coalition horse trading, not a public mandate, and nearly 90% of public submissions oppose it. Now, if this bill were simply about transparency, it could have focused on reinforcing tools we already have: regulatory impact statements, the Legislation Design and Advisory Committee, or the legislation guidelines, but that's not what it does. Instead, it imposes a set of principles that are anything but neutral. The so-called takings or impairment principle effectively enshrines the rights of the wealthiest actors in law. It creates a pathway, albeit indirect, for companies to demand compensation when Parliament enacts regulations that might reduce their profits. What kind of regulations would be called? Think about it. Any new tobacco, alcohol, food marketing, or climate regulation, zoning changes that affect developers, supermarket duopoly reforms, digital privacy rules, possibly even recognition of Maori rights under Te Tiriti that impact commercial interests. The principle doesn't define property. It includes anything from shares to fishing quotas to social media algorithms. There's no threshold for impairment, no standard for fair compensation. That's not transparency, that's opening the floodgates. And for what? Transparency we already have. At what cost? So let's talk cost. The bill's implementation is conservatively priced at $18 million per year, more likely much more, at a time when we're cutting frontline services. Is that the kind of fiscal prudence we believe in? And for what? Dozens, possibly hundreds of ministerial inconsistency statements telling Parliament that the law we're about to pass doesn't meet the standard of this flawed benchmark. All democratically elected governments need legislative flexibility. If this bill passes, any bold initiative, whether it's supermarket reform, modernising the RMA, or improving housing density, will likely trigger non-compliance. That is a political albatross, and ironically, it weakens executive agility, policy responsiveness, key traits of effective government. You may also be tempted to think, well, the courts can't enforce this, so it's fine. But judicial review is very much on the table. The bill enshrines these principles in statute. History tells us, just look at the development of New Zealand Bill of Rights Act jurisprudence, courts will refer to them. We are legislating an open-ended benchmark that will invite litigation and chill policy innovation. And what of sovereignty? The bill is an abdication of New Zealand's right to legislate in our own national interest. It mirrors the logic of international investor-state dispute mechanisms like the ones that let tobacco companies sue governments for plain packaging. We rightly rejected ISDS. Why reintroduce it domestically through the back door? National and New Zealand First pride themselves on standing for New Zealand's sovereignty. It's in your names. On putting the interests of our people above those of multinational corporations. But this bill does the opposite. It places the rights of investors, whether local or offshore, above the elected will of Parliament and the public good. It is fundamentally opposed to our shared liberal democratic heritage. But let me ask you plainly, do you want a future where Parliament is scared to legislate because a supermarket chain or a foreign-owned data company might claim impairment of property and demand compensation from the taxpayer? Because that is where this leads. Honourable members, this isn't good conservative policy. It's radical, brittle, and constitutionally reckless. The Legislation Design and Advisory Committee says this bill risks destabilising legal principles and encouraging litigation. Treasury said similar back in 2011. The Ministry of Regulation doesn't support it. Even ACT's own officials redacted their treaty advice. What are they hiding? You do not need to support this bill to support good regulation. You must oppose this bill because you believe in responsible regulation, because you believe in parliamentary sovereignty, because you believe in fiscal discipline and legislative integrity. This is your opportunity to show that National and New Zealand First don't take their cues from ACT's extreme anti-empirical ideological project, but from what's best for New Zealand. Reject this bill. You'll be doing your parties, your country, and your legacy a service. Thank you.
Oh, thank you, Paul. You've filled in that 5 minutes beautifully. I've got no questions from members. There's a wave there from Dr. Webb, just to an acknowledgement of thanks, I'm sure. So
Thanks, Paul.
Kia ora.
There we go. So thank you for reacquainting with Dr. Webb, and thank you for submitting to the Select Committee this morning.
Thank you, Mr. Chair.
Okay, thank you. Okay, Mr. Clark, are we back on track, dare I say? Have we got the Inclusive Greens Network Executive? Is that where we're at?
Yes, that is.
Oh, we've landed back to where we should be. Okay, 11:26 for 11:25. We've got the Inclusive Greens Network Executive online. Who's going to be talking to that?
That would be me.
Hi.
Oh, very good. Oh, well, thank you. Whereabouts are you coming from today?
I'm calling in from Tamaki Makaurau.
Very good. It's raining up here, so you're in a good place inside. We look forward to your presentation.
Awesome. Kia ora, everyone. Thanks for allowing me to present. Ko kei den takuingawa. Kei te korero ahau mō ngā Inclusive Greens te ropu whaikaha o te Pāti Kākariki. My name is Kei Din, and I'm here speaking as the co-convener of the Inclusive Greens, the disability network within the Green Party. I'll take it that our written submission has already been read. I know personally just how tiring it is to be disabled and having to fight against both the public and private sectors just to have my rights upheld. I know of many who give up this fight because it is too hard to simultaneously fight the system while trying to stay alive and just survive. This bill will not only make those fights much harder, it has the potential to shut down any current avenues that allow us to fight for our rights, which goes against the United Nations Convention on the Rights of the Disabled Person. This bill focuses on what is most efficient and profitable, which disregards entirely the value of life and our democratic processes. Profit should never come at the expense of our lives and well-being. The inquiry into abuse in state care showed some horrifying examples of abuse that our disabled community has suffered when organisations are given too much power. What happens when a ramp is deemed too expensive to install and a wheelchair user becomes trapped inside a building in an emergency? Aotearoa already lacks robust accessibility legislation, giving organisations power to prioritise profit, allowing for shortcuts. This will severely compromise our safety and accessibility. What about the agencies who provide support services if they are focused on profit and property rights rather than the well-being of their clients? Not just disability support, but support for queer or refugees who are also disabled. This bill allows for disabled rights to be violated in favour of a company's freedom and profit margins. Even in the public sector, this will allow for governments to cut necessary services just to fit in with a limited budget. This will cause significant harm to all disabled in Aotearoa. Now, the Regulatory Standards Bill has a section that talks about the importance of consultation with those who will be directly and materially affected by it. Yet this was not done for this bill. This shows that those who put forth this bill believe that it should not apply to them, or simply do not care about the harm this would do to minoritized groups in Aotearoa. As it stands today, many minoritized groups, especially disabled, have been and still are treated unequally under the law. This bill will only further increase the inequitable treatment of the disabled community while giving private organisations the freedom to ignore our fundamental human rights. Sonia Cooper, a lawyer that represents survivors of abuse in state care, said that those that she represents have a very distinct and urgent set of needs that would not be addressed by being treated as equal under the law due to our disabilities. The Waitangi Tribunal released a report stating that even the introduction of this bill is a breach of Te Tiriti, let alone allowing this bill to pass. The bad faith and arrogance behind this bill, considering all the efforts at resolving past injustices and working together, is breathtaking. Systemic inequalities already cause whaikaha Māori to experience poorer health outcomes, including extra barriers to education and employment. This bill will only lead to the worsening outcomes for whaikaha Māori, as it goes against both Te Tiriti and the UNCRPD. The services that do exist for whaikaha Māori only exist because of the collective rights whaikaha Māori have through Te Tiriti. The RSB sidesteps Te Tiriti, favouring corporations and individual freedoms, which puts all of these collective rights at risk. The Waitangi Tribunal made a point. Emphasis on formal equality fails to acknowledge that equal treatment does not create equal outcomes, especially when there has not been equality from the outset. To otherwise elevate equality over equity reduces the rights of Māori as Indigenous people. This also reduces the rights of all minoritized groups to fair and equitable treatment under the law. We ask that the government do the right thing and halt all further progress on this undemocratic bill as recommended by the tribunal.
Thank you very much. Loud and clear. I'm going to go to Marama Davidson for a question.
Thank you very much, Mr. Chair. I'm not surprised at all, Kay, to hear such a compelling kōrero from you. And I wanted to pick up on an example you raised, for example, where a ramp might be too expensive, and that given the context that we already lack robust inclusive accessibility legislation, would you like to share with the committee and people listening other examples then of how you can see the RSB having that very real life examples of having that detriment on the communities that you're speaking for? Thank you.
Well, already we have disabled people that are basically under house arrest because they can't get access to equipment services under our current legislation, which this bill will just increase that even further. As of right now, the only reason why I have my wheelchair is because I do need to use it at home as well. Those that need a wheelchair to leave their house can't get access to that at the moment. And under the RSB, it's going to be even harder. And they'll be able to decline things like being able to have a ramp installed so I can leave in my wheelchair and that kind of thing. There's also when organisations are allowed to say that profit and the expense is too much, that only 0 points so much percent need to use those accessible safety measures. This means that when one of those people are in that situation and something does go wrong, they're not going to make it out because those safety measures may only apply to 1 or 2 people out of 100, but those 1 or 2 people deserve to have a safe way and a good life.
Okay, very good. We might just leave it there. Thank you so much for coming to us from Auckland today. We appreciate that, and thank you for the work and effort you put into that submission, Kay.
Thank you so much.
Thank you. Okay, now I see on our chat that we've got Pauline Mackay, and Gareth Nolan Foreman from the Christchurch Central Methodist Parish ready to go. welcome.
Oh, yeah. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Thank you for this opportunity to speak to this bill. We are Pauline Mackay
and Gareth Allen Foreman,
the two parish stewards of the Christchurch Central Methodist Parish, more commonly known as Durham Street Methodist Church. In Te Hāriwetiana o Aotearoa, the Methodist Church of New Zealand, parish stewards are voluntary lay leaders of our parish. As a faith community, we affirm the sacred value of every person and of the environment we live in. Interactions between people cannot be reduced to a mere set of financial transactions. A fair and just society cannot be built on laws which look only at narrow cost-benefit analysis and ignore less tangible objectives and respect both people and the planet. We stand especially for those who have been hurt, put down, or excluded from society. We stand in solidarity with those who care for the earth, those who believe in social justice, those who believe a better world is possible and aren't afraid of being part of making that happen. Thus, we oppose the current bill for three main reasons.
First, we believe it's fatally inadequate and unbalanced. Some of our most important values, as many other submitters have said, as a society are missing in action from this bill. We have no problems with promoting responsible laws and regulations, but believe the current bill will not achieve this, primarily because of its narrowness and unbalanced approach. It acknowledges neoliberal rule of law and private property rights, which are a part of the equation, but leaves out all the balancing social democratic values of public and collective interests, social equity and cohesion, care for the environment, honouring te tiriti, and protection of the rights of vulnerable or minority groups. The result, therefore, is highly partisan and, as a result, a bad law, especially for a law that proposes to affect how all laws are made. As we noted in our written submission, our predecessors, the early Wesleyan missionaries, having encouraged the signing of te tiriti in the first place, were compelled to speak up in defence of Maori rights and interests when those rights were overridden and te tiriti was breached within a few years of signing the treaty. We have no less an obligation today when a bill, with limited exceptions in respect of treaty settlement, ignores te tiriti when determining the criteria and process for what purports to be good lawmaking. Te tiriti is a cornerstone of our nation and should be a cornerstone of good lawmaking. Similarly, our commitment to upholding the sacredness of creation drives us to intrinsically value our environment and its care. This should also be reflected as one of the balancing factors in good lawmaking, but again is missing from the bill. Also, our commitment to social equity and inclusion for all, especially those most marginalised. This means we see collective responsibility and social cohesion as important as individual rights and responsibilities. This should be reflected in any principles of responsible and effective regulation, but once more is completely absent from the bill.
Secondly, we are concerned that the proposed bill will reduce accountability and even potentially undermine democratic process. Many more experts than us in jurisprudence have pointed out that, ironically, for a bill that aims to promote good lawmaking, the current bill itself represents poor lawmaking, from the concerns of the Clerk of the House about breaching important parliamentary conventions to the Ministry of Regulation's concern about inadequate consideration of alternative approaches, which are likely to be more efficient. That it causes such reservations from many constitutional and other legal experts should also give us pause for concern. In particular, we agree with those who have argued that a law that purports to have constitution-like effect, determining how all laws are made, should have bipartisan support across Parliament and society, and the most cost-effective and effective alternative approaches should be explored before a particular approach is finalised. It can be argued that if passed into law, the principles would not be completely binding, so we shouldn't worry. as they could be overwritten by Parliament if certain regulatory hoops are jumped through. However, the bill is remarkably wide-reaching, applying to all future laws and regulations, and progressively to existing laws and regulations. In addition, laws are meant to articulate community expectations, and the credibility of the principle is undermined if they need to be routinely overridden. The intention and moral force is clearly that the legislation and its principles should apply. Thus, we should ensure they are appropriately comprehensive and balanced, which the current principles are not. The very purpose of this bill, greater transparency and accountability of legislation, is not served by setting up principles that need to be routinely overridden for good public policy reasons. Better still, to embed an alternative approach would approach a balanced and less partisan range of good regulatory principles. Unfortunately, as the Ministry of Regulation concludes, these alternative approaches were not adequately assessed.
Third and finally, and related to the above, we share the concerns with Treasury and others about the risks of legally exposing central government, local government, and we potentially understand some other parties to wide open compensation principles and approaches to regulatory takings that go too far. These financial vulnerabilities are open to be exploited by multinationals and foreign corporations as much as local businesses. Anyone who can argue a commercial interest is affected, for example, by precautionary regulation of emerging substances, synthetics, vapes, edibles, by harm reduction policies or protection of vulnerable groups, such as limitation of children's access to social media, by regulation of foreign ownership of strategic assets, media, agriculture, or national infrastructure, by long-term collective well-being, environmental protection, or climate adaptation, like managed retreat, emissions controls, and polluter pays principles, by implementation of treaty obligations outside of the narrow range of exclusions, and even by measures to promote competition, for example, among supermarkets, banks, or others, or anything that would reduce the profits of incumbent companies. As well as these financial risks, several experts, including Treasury, have identified that this could have a chilling effect on and undermine or weaken useful regulation. Thus, the fear that this blunt and poorly designed legislative weapon will undermine good and needed regulation just as likely as it will deter poor regulation.
As this bill represents poor value for money, can have a chilling effect on good regulation, unnecessarily exposes our country to unqualifiable financial risks, and is narrow and unbalanced in its approach, ignoring important Kiwi values of fairness, care of the environment, and respect for Tiriti. We strongly urge the committee to recommend to the House that the bill not proceed, but instead properly investigate bipartisan and more effective and cost-effective alternative approaches to enhancing the quality of lawmaking without these substantial negative side effects. Thank you once again for the opportunity to discuss our concerns with you in person. We particularly value this as we appreciate you have had many submitters to accommodate. Thank you.
Oh, thank you very much, Pauline and Garth. We're into the final minute, but I'm going to give a quick question to Dr. Russell.
Thank you for your submission this morning, and I'm broadly sympathetic to it. I'm going to ask you a question I asked another Christian group. If you could point to, not necessarily exact chapter and verse, but passages, particularly in the Gospel, that support your analysis. And as I said, I am sympathetic to it, but if you can just give me a steer on maybe some of the parables or the stories or particular passages that inform your approach.
Well, I think we'd resist picking out a proof text. It's not really our approach. But I think the key messages of Jesus' life and teachings were concern for those who are excluded and on the edges. And we need to take proactive steps to include those and support those. And I think anything that would get in the way of that is contrary to the gospel intentions. And there's also a strong theme through the whole of the First Testament as well as the New Testament on care and protection of the creation, and respect for people and the human dignity of everyone.
Thank you. That's exactly the sort of answer I was looking for. Thank
So
you.
more who is your neighbour rather than can I have his stuff?
Okay, well, thank you, Dr. Duncan Webb, for your translation there. Very good. Thank you, Pauline and Garth. Keep up the good work in Christchurch. We appreciate you joining us this morning.
Thank you.
Thank you.
Thank you. Okay, members, that leaves us to the final one before the lunch break, the final submission. Have we got Jenny Campbell from CAM? Is she here, Mr. Clark?
Yes, I am. Yes,
Oh,
I am.
yes.
Yes.
Hello, Jenny. Where are you coming from today?
Murihiku, Southland, but I'm actually in Balclutha with my great-grandchildren.
Oh,
and the
wow.
dog. And the dog.
Jeez, well, that's good to be with the great-grandchildren in the school holidays. Hey, look, you've got 10 minutes. We look forward to your contribution.
Kia ora. Kia ora e hōmā, members of Finance and Expenditure Subcommittee. He iti he punamu, it may be small, but it is very precious. Ko reti toku awa, ko takatimi toku maunga, ko takatimi toku waka, ko nai tahu toku iwi, ko te rau aha toku marae, no Mossburn toku kāinga ki Murihiku, ko Jenny Campbell aho. I'm speaking as co-convener of Coal Action Murihiku, CAM, along with personal perspectives. He waka eke noa, we are all in this together. This proposed bill shows no consideration for honouring and giving acknowledgement of Te Tiriti or Waitangi as our founding document. Those Te Tiriti principles bring with them the essential need to fully consult with Maori and the kaupapa around solutions and understanding of our need to work together on a consultative basis, valuing tangata whenua's long-term wisdom for their lived experience here as our First Nation people. This is particularly relevant regarding biodiversity, along with the appreciation of the need to protect te ora or te taiao, including our rivers, oceans and land from the mountains to the sea, as the habitats of our precious native species, our taonga. Crown policy must give full effect to Te Tiriti in involving and consulting with Maori, as well as measures to enable iwi, hapu and whānau to exercise their rangatiratanga and kaitiaki role in respect of taonga within their rohi. These injustices have not been redressed as under New Zealand's Bill of Rights, an indictment of our lack of appreciating equity as opposed to equality. CAM members recognise the significance of the articles of Te Tiriti or Waitangi and New Zealand's Bill of Rights Act, which have withstood the tests of time. We are submitting about these injustices as outlined in the proposed bill against present and past generations of Maori in particular, along with those who will follow in our footsteps, our mokopuna and their mokopuna, well into the future. If we do not speak out for Maori, our futures will be greatly affected and justice and our human rights severely impacted. The proposed regulatory standards bill has implications which could reshape how New Zealand governs itself. We have real concern that this proposed bill and legislation could have strong and sweeping impacts on government services, environmental protections and the very structure of our democracy. Many of the bill's principles are constitutionally and practically very worrying. There are broader democratic risks stemming from misinformation and the erosion of trust in public institutions. All of these are concerns for CAM's members. The Regulatory Standards Bill fundamentally breaches Te Tiriti or Waitangi and tries to essentially remove our founding document from future lawmaking. Its principles aim to exclude Te Tiriti or Waitangi entirely. By putting liberties, rights and private properties as principles over and above obligations and the protection of the common good, the bill could force the rewrite or change of meanings of many existing laws and regulations. It would threaten any safeguard for the environment and communities. By Omitting any principles that relate to Te Tiriti or Waitangi, the bill has the potential to sideline Te Tiriti-based protections from existing and future laws and policy. The proposed Regulatory Standards Board, charged with overseeing compliance with the bill's principles, would have enormous power. Under the influence by vested interests like the mining and industrial agriculture and fishing industries would mean suffering for Aotearoa's citizens, particularly Maori, migrant workers and other marginalised groups, as well as activists working for social and environmental justice. The proposed principles in the bill would create a new unprecedented expectation that the government pays corporations taxpayer money if new rules impact their property, even if those rules are to stop pollution, protect nature, or prevent harm to people and communities. The proposed bill does not act in the public interest. Restrictions on taxes and charges could undermine publicly funded healthcare and education, so eroding public services. Deregulation could erode minimum wages, working conditions, and health and safety standards, and so weaken workers' protections. It is likely to increase taxpayer costs, with corporations being able to seek compensation for regulatory changes to their property rights. These could happen through government actions to mitigate risks to public health or the environment, such as revoking the fast track or mining proposals or tobacco labelling control. Efforts to instigate or initiate activities to respond to climate change or environmental concerns could face legal challenges, so removing environmental protections. There is a lot of concern over the principle to prioritise corporate property and individual freedom over environmental protection, public safety and Indigenous rights. The absence of a principle about equity risks the prioritisation of corporate interests over community and collective social good. This will marginalise collective community rights, and especially those in the disabled community. Facing imminent ecological and social crises, we need to work cautiously and collaboratively with common good, social equity and ecological health and resilience at the heart of our legislation. This proposed bill goes diametrically against these. Personal income and property rights take precedence. Its aim is to provide more freedom for businesses to operate and reduce government involvement in economic management, with the environment and social justice not being priorities. This does not sit with what Aotearoa society stands for. In contrast to promoting liberty and economic freedom, a more collective and equitable approach is needed. This proposed bill, through its regulatory process, limits the consideration of social and environmental impacts for economic gain. We have very real concerns for the future of our country's democracy if this bill is moved through the House. The ability of any future government to respond to the very real crises we face, including climate change, inequality, freshwater pollution, biodiversity loss, it goes on, without being tied down to legal threats and corporate claims, is at very real risk under this proposed bill. The bill and the process being followed is an insulting attack on our sense of community and caring for each other. Democracy for the common good is a mark of our society, along with kindness and caring for others in our society who are not so advantaged. Can members submit that this bill be withdrawn immediately? We are totally opposed to the proposed Regulatory Standards Bill and submit that it should not proceed any further. This proposed legislation is not needed in Aotearoa. Whakatoki, Te tiro whakamuri, ko kiri whakamua. Look back and reflect so we can move forward. He iti he punamu. It may be small, but it is very precious. Thank you, panel, for your respectful listening to my concerns.
Oh, no, thank you, Jenny. I'm going to, we've got just a couple of minutes, so I'm going to go to Marama Davidson just for a quick exchange.
I appreciate that, Mr. Chair. Kia ora whaia, Jenny. I'm coming to you also as a nana, a proud nana with mokopuna. You talked a lot about protecting taiao And I wondered if you wanted to give the Select Committee a chance to hear about exactly what it is that you look forward to, your local taiao, your local environment and community, the activities that you look forward to and share with your mokopuna, with your whānau, if you wanted to give us a bit of a taste of what that is for you, what that means for you.
I think it's the freedoms we have in New Zealand and the lack of fear for young children, because there's so much going on with regard to climate change, water pollution, industries not being thoughtful of workers. And we really don't need any more of that kind of legislation that's not protecting what we hold as precious. We all have different views, obviously, but the common good is what I seek, and my mokopuna need to have the same chances in the world as I've had. I've been brought up in a very blessed time, and I appreciate every single day the things I've been given in my lifetime. I'm very privileged and very rich from all sorts of angles.
Thank you, Jenny. And those great grandchildren are very well behaved too. We haven't heard a squeak out of them. So you've got the measure of them as well. Hey, look, thank you for your time and for submitting from Balclutha today to the committee. We really appreciate that.
Ka kite.
Thank you. Members, we're going to click off now and come back bang on 12:30. Thank you so much.